stand up and honor them in the minute of silence. That would be great. Thank you so much. Thank you very much. And now please welcome the Interim Ambassador of Ukraine to the United Kingdom, Edward Fisker. Thank you.
Thank you. Dear colleagues, I would like to start by conveying our deepest thanks to the NGO Justice and Accountability for Ukraine and partner organizations for putting this event together. And thank you all for attending it today. While the damage caused by the Russian invasion can never be undone, what can be done is to ensure that those responsible are brought to justice. Not only can it be done, it must be done. There is no doubt that after atrocities committed in Bucha, Irpin, other cities and towns in Ukraine, there is a pressing need for establishment of a special tribunal to fill the accountability gap. Will Russia ratify the Rome Statute? Will the UN Security Council refer the case to the International Criminal Court? We all know the answer to these questions. Thus, a special tribunal is the only viable path to provide justice, which is a prerequisite for a just and lasting peace in Ukraine. That is why justice is one of the points in President Zelensky's peace formula. That is why Ukraine explores all possible venues to ensure that justice is served, namely the European Court for Human Rights, the International Court of Justice, the International Criminal Court, an envisioned special tribunal for the crime of aggression, a planned compensation commission, national jurisdiction. Both those who gave criminal orders and those who carried them out must be brought to account. We believe there is a strong argument in support of creation of a special international tribunal to try the highest political and military leadership of Russia for the crime of aggression. To that end, we need to ensure legitimacy of such a tribunal, choosing the right model for it. And we appreciate the work of the core group on this track. I hope that the model, given the tribunal the highest degree of legitimacy, could be soon agreed among the participating countries. This is crucial, as the absence of a unified response from the international community plays into the hands of evil. While we discuss potential models of the special tribunal, each day people continue to suffer and die as Russia continues to violate each and every norm of international law. One can hardly imagine how painful is the loss of dear ones to friends and families. However, it is quite excruciating to witness the continued perpetrations of killings and torture by the offender, who remains unaccountable while the world around takes its sweet time to discuss and debate and postpone a decision on the model for the special tribunal. Each day of delay instigates Russia as it remains convinced that its egregious crimes will go unpunished. The tribunal's establishment will in itself already send a strong signal across the globe that aggression does not pay. Russia has already been allowed to get away with too much in Georgia, Moldova, Ukraine in 2014. And for some reason, we continue hearing different voices preoccupied with guarding Russia's rights, as is the case with the issue of confiscation of frozen assets. Blatant Russian violations of international norms and principles, its war crimes, call for a resolute response. Even though those crimes are not happening here, now, in London, in the UK, at this very moment, and we don't experience them directly, it is no reason to ignore or forget them. Pacifying Putin and flirting with Russia does not work. There are ample evidences to this. The aggressor's appetite only grows with each subsequent invasion. Therefore, only unified actions towards achieving justice and punishing aggressor is the right response. And creation of a special tribunal is an important part of it. I'll stop here and defer legal discussion to the esteemed expert in this field. And it is my great pleasure to welcome our Minister of Justice, Mr. Denis Moluska, who will give his perspective on today's discussion. Thank you.
Ladies and gentlemen, dear colleagues and friends, well, let me first of all thank for our organizers for inviting me and arranging the conference. The topic we are here to discuss is of ultimate importance, and in order to start my small intervention, I would rather speak about the context of the topic we are discussing here, the context of a tribunal. Russians often complain that West did not listen to Russia, that Russia needs to be understood and heard. And here, actually, I tend to agree with them. We need to understand Russia and hear it, and we need to understand Putin as an ultimate and single decision maker in Russia. So Putin is obsessed with a history. Not a history we understand in his weird interpretation of a history, but still it's a history. And he compares himself to Russian tsars of 18th, 19th, 17th centuries. And those guys, those tsars, are his role models. He compares his achievements to theirs. And historically, in those centuries, it was usual behavior to attack a country, to take territory, to grab territory, to expand borders, and at a certain point have peace negotiations where maps are redrawn, borders are shifted, and new governments or new kings are imposed on certain territories. So that is his current modus operandi. He understands that this model worked for centuries and it needs to be continued. Of course, our understanding is completely different. We understand that current rule-based order is different. You couldn't just move a border to a certain point when you are satisfied. You cannot attack a country and grab a territory. Now it's illegal actions, it's aggression, internationally recognized crime. And we need to send a message to explain not only Russia, but other countries as well, that rules have changed. And if civilized nations will limit themselves to only military response, like to fight a war, Russia launched a war. Okay, let's defend Ukraine, let's provide military support, etc. This will prove that 18th, 19th, 17th centuries are here and back. Those rules where the strongest party wins and takes everything what is needed are back. And Putin is right. To prove him wrong, we need to show that rules are different, that international law fights back, and legal actions matter, really matter. And with that purpose in mind, Ukraine calls for comprehensive mechanism of responsibility. Part of it, like getting reparations from Russian Federation, is already in progress. So international organization, Register for Damages was created, and we really work with that organization in order to make the Register for Damages operational this spring, to at least start gathering information on the damages caused by the Russian aggression, at least to certain categories of damages. We are negotiating with our partners on the creation of compensation commission which will deal with claims for compensation and which will be tasked to provide awards, like amounts of compensation to be paid to victims, not only natural persons, but legal entities, municipalities, and the state. And also we are working really hard on lifting sovereign immunity of Russian Federation over assets of the Russian Central Bank, which is a core initiative which will provide money to compensation fund and actually for payments of reparations. This is a more economic or financial part of the comprehensive mechanism. What we are talking right now is another dimension, criminal one. And of course, prosecution in Ukraine, in other jurisdictions, international organizations working hard on criminal dimension of responsibility are doing their job really well. But we all understand that those who are really decision makers are still protected from the reach of international justice. We really celebrated and really we're quite happy with the arrest warrant of ICC over Putin, but that arrest warrant covers, and that case investigation covers only a small part of crimes committed by Russian top-level officials. And we need to see a bigger picture, a picture which reflects the actual changes in the system of international law, where attack and aggression over territory of other countries is considered to be a crime. And for that purpose, we need a tribunal. We had quite long months and years of discussions. Not years, but soon it's going to be years. And I hope that the result of those discussions would be a real tribunal created, a tribunal focused on top-level Russian officials, and the message from international community would be sent. We are no longer in 18th, 19th centuries. We are now in the 21st century, where act of aggression is punishable, and there is a response from international community. Thank you, and looking forward to hearing your views and discussions.
The Conference on the Special International Tribunal for the Crime of Aggression against Ukraine. On 24th February 2022, Russia, supported by Belarus, attacked our country. The war in Ukraine continues. Every day, innocent people are being killed. Homes, hospitals, and schools are being destroyed, and the country is being ravaged. The invasion, occupation, bombing, and attacks on Ukraine, along with other aggressive actions, are among the most destructive and widespread in Europe since World War II. In February 2022, Ukraine and European partners called for the prosecution of Russian leaders, including President Vladimir Putin, for the crime of aggression. This call was also supported by a core group of 40 nations negotiating the creation of a special tribunal to try top leaders for this crime. The government of the Netherlands has offered to host such a tribunal. The key issue still unresolved is the model that governments can and should support. At present, the choice is between a purely international tribunal and an internationalized hybrid model, which unfortunately fails to address a number of important issues. At present, many countries are concerned that the hybrid model, which would essentially be a Ukrainian domestic court, cannot be implemented because it would delay and possibly eliminate altogether the prospect of bringing President Putin, President Lukashenko, Sergei Lavrov, and other senior leaders to justice, as they would enjoy personal immunity before a domestic hybrid tribunal. Moreover, such a model would deprive the Court of international legitimacy. On 20th January 2023, the UK supported the idea of a special tribunal, but has not yet decided on the model for its creation. We believe it is clearly appropriate to establish an international tribunal. We believe that it would be the best hope of lifting relevant immunities. We call on lawyers and experts to consider how a future tribunal could overcome the immunity of the Troika, the President, Prime Minister and Foreign Minister of Russia, and try them for the crime of aggression committed against Ukraine. Given its global influence and historic leadership on human rights issues, the UK can play a vital role in further galvanizing international support for its proposal. We urge you, colleagues, to do all you can to achieve. Thank you so much.
Thank you, everyone. Well, without further ado, we will introduce our first panel, Panel 1, which will discuss the history of special tribunals and the accountability gap. So thank you very much to Ms. Malesa, Mr. Ambassador Fisco, and Mr. Malyuska. And now could we please welcome to the stage Professor Dapo Akande, who will be moderating Panel 1. Professor Akande is the Chichele Professor of Public International Law, co-director of Oxford University's Institute for Ethics, Law and Armed Conflict. We are also joined by Dr. Anton Koronievich, Ambassador at Large for the Ministry of Foreign Affairs of Ukraine. Mr. Koronievich, welcome. We'll be joined on the live link by Justice Richard Goldstone, who is the first Chief Prosecutor of the United Nations International Criminal Tribunal for the former Yugoslavia and for Rwanda. We're joined by Ms. Alison MacDonald, KC, barrister and leading expert in public international law. And we are also thrilled to be joined by Stephen Doughty, MP, Shadow Minister for Europe and North America. I'll now hand over to Professor Akande to lead Panel 1.
Thank you very much, Bella, and good morning to all of you. Our panel will try to dig a little bit deeper into some of the legal issues that have already been covered by the Justice Minister, the Ambassador, and others in that opening panel. There has already been some discussion about the necessity for this tribunal. So why is it needed, both as a matter of law and in terms of the project of seeking justice? Also, some discussion about what the tribunal is intended to do. And so we have here 4 distinguished experts who will dig into these issues. We will cover issues like, what is the crime of aggression? What are the elements of the crime of aggression? Why do we need a special tribunal for the crime of aggression? And what are the challenges with regard to establishing this special tribunal? We'll also talk a little bit about the history of establishing international tribunals and what lessons can we learn from that history and what parallels can be drawn. And also, we will talk a little bit about the type of political support that will be needed for establishing a tribunal like this. As Bella's already indicated, we have 4 eminent experts to talk to us about these issues, and the order in which they will speak will be, first of all, Anton Korinevich, who is Ambassador at Large at the Ukrainian Ministry of Foreign Affairs, and who is really charged with leading this project to establish the Special Tribunal on the Crime of Aggression against Ukraine. He will go first. And after that, we will then have Alison MacDonald KC. She is a barrister at Essex Court Chambers. She has appeared before a range of international courts and tribunals, the International Court of Justice, European Court of Human Rights, and other international and domestic tribunals, an expert in public international law, also a member of the the Ukrainian Presidential Working Group on reparations with respect to the illegal invasion of Ukraine. After that, we will then turn to Justice Richard Goldstone, who is joining us online, and he was a judge at South African Constitutional Court for many years, and as you see on the screen, he was then the first prosecutor of the UN International Criminal Tribunal for the former Yugoslavia and Rwanda. He's also been involved with the ICC. He led, a few years ago, the review of the ICC. And then our last speaker will be Stephen Doughty, MP, member of the Labour Party, shadow minister, dealing with, amongst other things, dealing with global security in his brief. Each of them will speak. I think we've agreed for about 7 minutes or thereabouts, and then we will have time for Q&A. So the order will be Anton will go first. Over to you.
Thank you so much, Dapo. Good morning, dear colleagues. It's a big pleasure and honor to be here and to talk to this audience today on this important issue, and many thanks to the organizers of the conference for making this happen. Really in a very important moment as we are coming closer to the 2 years of the full-scale invasion of Russia to Ukraine, and we are, as Minister Maluska mentioned, we are working hard on all the tracks to achieve the comprehensive accountability, the full accountability, which will mean that actually there are no gaps in the accountability system, and that all the elements are satisfied, and that all the crimes or all the violations are covered, and the reparations and compensations are there to be done. So with this said, as our panel deals with the history and also what we have now and what do we need to do further on, I think it is really crucially important to understand that our idea to establish a special tribunal for the crime of aggression against Ukraine comes from the very understanding that we need to tackle, we need to punish, we need to investigate and prosecute not only the, I would say, crimes which comes after, but also the crime which is a primary crime, the crime which is the root cause of all the other crimes committed on our soil. And as you know, for 10 years, Russia is waging a war against Ukraine since February 2014. And it is crucially important to try Russian political and military leadership for the very crime of aggression. As if it wasn't this crime of aggression, which started in February 2014, then which had this new spirit in 2022, if it wasn't this crime of aggression, Ukraine would have never felt any single war crime, any single crime against humanity. We would not talk about genocide now. Before 2014, we had no war crimes committed on the territory of Ukraine because we had no Russian aggression within the framework of which all these mass atrocity crimes take place. So that is why we believe that while having the institutions which are working hard in order to bring Russian citizens to accountability, in particular the International Criminal Court, in particular the national courts of Ukraine, national systems of other states, we believe that we need to tackle the primary crime, we need to tackle the root crime. Moreover, when we look at the history of international criminal law and of international criminal tribunals, we also see that there should be a legal response for such a huge crime of aggression as we see now. This is the biggest war of aggression, at least in Europe, since 1945. And there should be legal response to that, as the Allied powers and the international community found the way to the legal response after the Second World War in the form of International Military Tribunal in Nuremberg and International Military Tribunal for the Far East. And the biggest percentage of the verdicts, judgments of the Nuremberg Tribunal were for committing crimes against peace. So were for committing crime of aggression, as we call it now. So if we look at this, and if we understand that the Russian aggression, Russian war against Ukraine is the biggest war in Europe after the Second World War, we also understand that we need to find a legal response. And the legal response should be the Special Tribunal, which will work with a single crime of aggression. We also understand, and we also are open when we talk with our international partners and colleagues, that if we had mechanisms which could do this now, we of course would not create anything which is not needed. But we see that accountability for the crime of aggression against Ukraine is important. It is an indispensable element of this comprehensive accountability mechanism. And we see that no other court, no other tribunal, no other international organization can do that. Moreover, the responsibility for the crime of aggression is of utmost importance for us, because as we see, the current system of international justice is structured in such a way that, unfortunately, we do not have a court where we could go to try Russia for its act of aggression as a state. We will not discuss the issues, whether this needs to be changed. Of course, it should be, whether some mechanisms do not work, but we cannot do this. And this track of individual criminal accountability for the crime of aggression, in this particular situation, leads us to the very idea that this is something what we do. If we do this, we will cover accountability for all the Russian war of aggression against Ukraine. We will tackle, we will cover the very root cause of it. So that is why we work on this issue, and that is why we convene a core group of states, which now include 40 states as participants and several international organizations. We are happy that we have a lot of supporters in our endeavor, both on political level, both on legal level, expert level, academic level. We need to move forward. So I think that one of the crucial issues is that we need to do, as during our introductory panel, our panelists and speakers spoke, we need to keep the issue on the agenda. before the solution is found. So it is really crucially important to talk about the issue, to discuss the issue, and to try to find the solution. And of course, the second notion is, again, what Minister Maluska rightly mentioned: we need to find a solution. The solution cannot be postponed. The solution cannot be the one which will not be satisfactory for the goal. And the goal is to try Russian top political and military leadership for the crime of aggression. We are sure that this is doable. We understand that international law gives us the grounds to do this. Commission of the crime of aggression on the territory of Ukraine and against Ukraine gives absolute possibility to establish a tribunal for this matter. The only question is the model. Whenever the model, the solution, the landing zone is found, it will be much easier for us to move forward. And we are sure that if we, together with you, together with our international partners and friends, if we don't do this now, the very concept of the non-use of force or non-threat of force, the very concept of the crime of aggression would remain in the history of international law, but will no longer be part of real international law. And the only thing which we will be able to do is probably maybe students of Professor Akanda will write papers on what the crime of aggression was before in international law and how it never happened. I will finish with, I think, one issue which I was thinking about today in the morning, a great book by great Finnish professor Martti Koskiniemi, Gentle Civilizer of Nation, The Rise and Fall of International Law. I don't think that we want now to see the fall of international law. And that's why we are here to make it rise and to make it work effectively. Thank you.
Thank you very much. Next, we'll turn to Alison MacDonald, who will talk to us about what the crime of aggression is and what its elements are.
Well, thank you very much, Dapo. I'm delighted to take part in these really important discussions today. So thank you very much for inviting me to contribute. We thought that since we are the first panel of the day, it would be useful, building on the remarks we've just heard, to set the scene and to put in place some basic legal building blocks. And in particular, we hear talk of an accountability gap. So what I'm going to try to do briefly to set the scene is to define exactly what the accountability gap is and how it arises. Obviously, the idea of a wrongful or an unjust war has been part of international law for centuries. But the idea, as we've just heard, of individual criminal liability for aggression was really born in the Nuremberg trials, where 12 defendants were convicted of aggression, or as it was also called on the indictments, crimes against peace. Fast forward to the establishment of the International Criminal Court by the Rome Statute. There, the definition of aggression proved to be contentious, so the statute came into force without aggression being included, and years of work continued so as to define that offence in a way that the states parties would accept and would include in the statute. And that wasn't so much because of disagreement on the core elements of the offence. So what aggression is, and I'll define it in a moment, hasn't changed very much over the years, as between the Charter of the International Military Tribunal at Nuremberg and the Rome Statute. So what it is was always fairly clear, but what was contentious in the Rome Statute process was much more the circumstances in which the ICC would be able to exercise jurisdiction. So that was the sticking point. Finally, Article 8 bis was added to the Rome Statute, and that defines, and I will just, so again, as a building block, that defines aggression as the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state. So pausing there, as we heard, it's a leadership crime. It can only really be committed by those who have the ability to direct the overall actions of the state, of an act of aggression which by its character, gravity and scale constitutes a manifest violation of the Charter of the United Nations. And it goes on to indicate that an act of aggression is the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations. So, as we've heard, we have a text, we could not have a clearer example of aggression being committed today by the Russian Federation and its leadership on Ukrainian soil. So as we've heard, I mean, if this is not an aggression that would give rise to accountability, it's hard to imagine what would. The challenge and what has generated the need for a special tribunal is that there are, despite the clarity of the definition of aggression, there are very narrow circumstances in which the court would be able to exercise jurisdiction over it. And the lack of the ICC's jurisdiction, and I'm going to just in a moment delve briefly into the Roman Statute so we all know why it can't look at aggression, although it can look at the other things that it's looking at, and we've seen indictments being issued, for example, in relation to in particular, the abduction of children. The lack of ICC jurisdiction is important because it means that the initiative to find a separate way of prosecuting for the crime of aggression is not duplicating the work of the ICC, it's not usurping it. As we've heard, if the ICC was able to act in relation to aggression, we wouldn't need to be here. So again, there's no duplication, and the reason for that is because of the very, I think, cautious way that the states parties to the Roman Statute have defined the ICC or given the ICC routes to jurisdiction. So neither Ukraine nor the Russian Federation is a party to the Roman Statute. Ukraine, as we know, has accepted the court's jurisdiction under Article 12.3 of the statute, and that provides the court with jurisdiction over crimes against humanity, war crimes, or genocide arising from the current conflict. So it's on the basis of that that the ICC is conducting its work in relation to the conflict. The prosecutor has already, as we've seen, opened an investigation, and we've seen that there have been indictments. But that doesn't include aggression. The statute in Article 15 bis, which was inserted when aggression was signed off for inclusion in the statute by the states parties, specifies that the court shan't exercise its jurisdiction over the crime of aggression when committed by the nationals or on the territory of a state that's not party to the statute. Now, even if both states were to become states parties, which is obviously unlikely presently in the case of the Russian Federation, their ratifications wouldn't have retroactive effect. The declaration that Ukraine has made, or any other declaration under Article 12.3, can have retroactive effect, but that doesn't in itself make the state that's making the declaration a party to the Roman Statute. So it's unlikely that any form of declaration will be able to overcome the obstacle that's posed by Article 15 bis. Now, the other route that was provided in the statute is, of course, a referral by the UN Security Council, and, of course, unable to act in the present case. There's a broader conversation to be had, of course, about the veto system and whether that is something which now serves the interests of international peace and security, but this is a pressing issue which must be taken forward without setting a hurdle of having to revise the architecture of the United Nations. So we have a situation where, for the slightly intricate legal reasons that I've just defined, so we know what they are, what the Nuremberg Tribunal called the supreme international crime, which is being flagrantly committed as we speak, does not have a mechanism for individual criminal accountability. Now, many questions, of course, arise, which will be explored across the panels today, about how this gap can be filled in the most legally robust manner. And some of these questions, for example, the authority of the UN General Assembly to create international mechanisms, are also being explored in the context of reparations, which is, again, has been the subject of a resolution of the General Assembly. Another key question, which has been touched upon in today's opening remarks and is important to explore further, is the question of immunity. As we've just seen, aggression is quintessential leadership crime. It can only be committed by the leaders of a state. The International Court of Justice in the arrest warrant case indicated, without very detailed reasoning, that the personal immunity in that case of a foreign minister, it would also apply to the other two members of the Troika, the personal immunity does not apply before a quote-unquote international tribunal. So that raises the question, and mechanics are going to be looked at in a number of the panels today. That raises the question of what is an international tribunal for the purposes of immunity? What characteristics does it need to have before it's lifted onto the international plane to a sufficient degree that it can override the personal immunities of those that one would most want to see in the dock of such a tribunal. I hope that's been helpful in just setting the scene, and I'll hand back to Dapo.
Thank you very much, Alison. So having talked about why the tribunal is needed, the accountability gap, what we're now going to do is to sort of look backwards a bit and look at other occasions when the international community has sought to establish international tribunals and to see what lessons we can draw from those kinds of situations. So we're going to turn to Justice Goldstone, who will draw from his experience as the first prosecutor of the International Criminal Tribunals for the former Yugoslavia and for Rwanda. Thank you very much, Justice Goldstone. Over to you.
Thank you very much, Professor Akande. I'm very grateful to the organizers for having made it possible for me to join you virtually from Cape Town. I regret that I cannot be with you in person. My experience with international criminal law has taught me that politics and political will lie at its very core. Without the political will, there would be no international criminal tribunals, and without the political will, they would not be able to function at all, let alone to fulfill their mission. The decision to try the Nazi and Japanese war criminals after World War II was a controversial political decision taken by the leaders of the victorious nations. It was driven by the United States, led by President Truman, who prevailed over the negative views of Winston Churchill. The gap of almost 50 years before further international criminal tribunals were established was a consequence of the Cold War. The politics during those almost 50 years was against fulfilling the promise of Nuremberg, and the political will to do so was absent. The decision by the Security Council in May 1993 to establish the ad hoc criminal tribunal for the former Yugoslavia was clearly a political decision by a political body. The Western Alliance considered that some form of justice might assist in bringing peace to the Balkans. Not without reluctance, Russia and China voted for it. Blatant and cynical politics with regard to the appointment of a chief prosecutor almost wrecked the whole endeavor. The statute for the Yugoslavia Tribunal provided that the prosecutor was to be appointed by the Security Council on the nomination of the Secretary General. In February 1994, in fact, the first prosecutor, Ramon Escobar Salom of Venezuela, resigned almost immediately upon taking office. It's for that reason that I'm referred to usually as the first prosecutor. In fact, technically, I was the second. Then between February and June of 1994, there was no prosecutor. No less than 8 of the nominees of the Secretary General were rejected by one or other member of the Security Council. Russia vetoed 5 of them, presumably because they came from members of NATO. Eventually, in July 1994, with the intervention of then recently appointed President Nelson Mandela, I was unanimously appointed as prosecutor. My appointment was very much a political one in the desperate situation in which the ICTY appeared to be on the brink of collapse. At the end of 1994, the Rwanda Tribunal was established, even though the government of Rwanda that had called for it had withdrawn its request. It objected to the manner in which it would operate, and particularly that it would not be cited wholly in Rwanda. Rwanda was then a member of the Security Council, one of the non-permanent members, and it cast the only vote against the resolution establishing it. For political reasons, the Western members of the Security Council had decided that the Rwanda Tribunal should be established, notwithstanding the opposition of Rwanda. There can be no doubt that without the ICTY having been appointed in a European situation, Security Council would never have established an ad hoc tribunal for an African situation. That is the reality. Though the establishment of the two ad hoc tribunals was a direct consequence of the politics and of political will, that is no less true with regard to the manner in which they operated. In 1994, the Yugoslavia Tribunal issued its first indictments against Bosnian Serb officials, but the United Nations forces in Bosnia refused to arrest them, even when they passed through UN roadblocks. I was more than shocked that a United Nations military force would not actively assist an organ of the United Nations Security Council. The reason for their reluctance, in fact their refusal to effect arrests, was the fear, especially by the United States military leaders, that the arrest of Serb defendants would result in the violent retaliation by Serb nationalists against the UN officials and the troops in Bosnia. The official, if hollow excuse for the failure to effect arrests was that the UN military was not a police force and that it was not for the army to make such arrests. Again, it was the politics, and especially in Washington, D.C., that dictated that policy and those actions. The relevant European governments hid behind the skirt of the Americans. Then in 1997, there was a change of government in the UK, and a strong new foreign minister came into office, Robin Cook. Together with Klaus Kinkel, his counterpart in Berlin, they demanded a change in policy, and that resulted in arrests being made by the international military personnel in Bosnia. Eventually, every arrest warrant issued by the ICTY was executed, every one of them. Turning to the Rwanda Tribunal, it was to the credit of the government of Rwanda that it assisted us in setting up the Office of the Prosecutor in the Rwandan capital, Kigali. The government provided premises and instructed its police to ensure that we were secure and able to travel throughout the country to visit crime scenes and to communicate with witnesses. Without the political will of the Rwanda government, the tribunal could not have functioned at all. Funding for the ad hoc tribunals was a running problem from the day each of them started up. The UN was critically, as it usually is, the UN was critically short of financial resources, and every dollar spent on the tribunals was a dollar less for other organs of the UN. Pressure from relevant governments on the UN Secretariat was crucial in freeing up funds for the tribunals. Hence, the funding of the tribunals was also the consequence of political will. Allow me to conclude these introductory remarks. Having set up the two ad hoc tribunals for the former Yugoslavia and Rwanda, the Security Council lacked the political will to set up a third ad hoc tribunal for Sierra Leone. That was notwithstanding a direct request from the government of Sierra Leone for it to be set up. It was in that context that the Security Council instructed the Secretary General to establish the Special Tribunal, the Special Court for Sierra Leone, as a partnership between the government of Sierra Leone and the United Nations. The Sierra Leone Tribunal was thus established directly by the Security Council, was not established directly by the Security Council, and thus did not have the powers that flowed from the peremptory provisions of Chapter 7 of the United Nations Charter. Sierra Leone Tribunal was also not funded by the United Nations, but by Sierra Leone and by voluntary contributions from friendly governments. Clearly, political issues are driving the debate about a special tribunal for Ukraine. That is unavoidable, whether such a tribunal is established in partnership with the UN through a General Assembly resolution, or by the Ukraine in alliance with supportive governments outside the UN framework. But one thing is clear, without positive politics and the necessary political will, there will be no special tribunal for Ukraine. The two ad hoc tribunals were recognized by the International Court of Justice in the arrest warrant case, to which Alison MacDonald has just referred. It was referred to as international courts, and thus not subject to any limitation by reason of head of state immunity. It is thus essential, I would suggest, that a special court for Ukraine should also be an international court. It follows that the political will to have it established pursuant to a resolution of the General Assembly of the United Nations is crucial. Thank you for your attention.
Thank you very much, Justice Goldstone. So we're going to turn a bit from the legal to the political, and we have Stephen Doughty, MP, who will talk to us about some of his own work in this regard, but more generally, the kind of political support that would be needed for this tribunal.
Thanks very much. Well, thank you very much for having me here today, and it's a real honour to be particularly amongst such distinguished and eminent fellow participants in the panel and in the room as well. I should say from the outset, I'm not a lawyer, I'm not an expert, I'm a mere politician, but I can assure you of our support for a special tribunal from the opposition, and actually at a time of incredible political division in the UK. We're obviously in an election year. The issue of support for Ukraine is not an area where there is division. You will see repeatedly in the statements that we make, the close cooperation that we have with the current UK government, that we are supporting Ukraine in military terms, in diplomatic terms, in political terms, and in terms of the fight for justice and accountability. And were there to be a change of government, you would not see a change in policy on Ukraine, and I think it's worth emphasising that. Particularly when we see some of the divisions elsewhere in the world. And it's a pleasure to be with the Minister and ambassadors and others, and also good to see other ambassadors and high commissioners in the room as well. It's great to be amongst the company of other fellow like-minded states who are coming together to try and support this fight for justice and accountability. I think it's really important when we're thinking of history. You know, history matters. This room matters, actually. This building matters. I'm sure it's been mentioned already, but this building was actually used in the Second World War as an alternative location for Parliament when the House of Commons had been bombed, so there's significance in that regard. It was also used as a place of preparation, actually, for evidence for Nuremberg, this very building. It was used, actually, as the place where the UN Charter was originally debated and prepared. And it was actually the place where the first sitting of the UN Security Council took place. So I think it's very auspicious that we're holding this event here today. But of course, and reflecting on what Justice Goldstone has just said, this fundamentally comes down to political will, because history matters. It informs us, it can inspire us, it can warn us, but it does not have to constrain us. We make our own futures. The challenges, and we've heard many of the different technical legal challenges and the different examples, the different tribunals and different models that existed before. As I said, they can inspire us, they can inform us, but they do not have to constrain us. We can find politically and legally legitimate ways of innovating and finding ways to ensure justice and accountability for Ukraine, and indeed with wider implications for the international rules-based order that have been referred to on a number of occasions. And that fundamentally does require that political will. And so I think the significance of the number of states that have come together in support of a special tribunal matters, and it would matter for the United Kingdom to play a key part in that going forward. I should also reflect, the moral and evidential case is very, very clear to me. I've visited Ukraine twice since the start of this phase of the war. In fact, actually, on the first time I travelled back in September 2022, I was in a carriage travelling through the night with Jeffrey Nice, who, of course, was one of the prosecutors at the International Criminal Tribunal for Yugoslavia, and we had an extensive conversation in the midst of the night, rattling along on Ukrainian railways to Kiev, which, of course, was under attack, and I've been there during air raids. I've visited Bucha, Irpin, Hostomel. I've met with those who have suffered directly from the Russian aggression. I've met with veterans, I've met with families. On my last visit to Kiev in September, I was able to go into bunkers where children are having to be educated under fear of bombing and that aggression from Russia. So I've seen directly myself the evidence, and that is utterly clear. In terms of the political will and our position going forward, our leader, Sir Keir Starmer, the leader of the opposition, of course, an eminent lawyer in his own right, our former Director of Public Prosecutions here in the UK, he called, actually before the government here in March 2022 for the creation of a special tribunal for the crime of aggression. And, of course, we welcome the other ongoing efforts, the ICC and, of course, the domestic war crimes investigations which are happening in Ukraine, and we will continue to support the UK government in their support to Ukraine in this area, whether that's in terms of investigations, in terms of prosecutions and elsewhere, and also to support the work of the ICC. But as we've heard throughout this presentation, there is a real deficit in accountability, and we believe that it's important to pursue a distinct complementary legal route to ensure that Ukraine and its people receive justice, and for those ultimately responsible to be held to account. And that means that we hold Putin and his inner circle to account for the so-called mother crime, the original sin, the crime of aggression. And in that regard, we completely support what the Ukrainian government, President Zelensky, Foreign Minister Kuleba, and of course our Justice Minister here today have said on this matter. It's very, very clear the United Nations General Assembly adopted the resolution in March of 22, right after this phase of the invasion. It was very clearly entitled Aggression Against Ukraine. It condemned in the strongest terms the aggression in violation of the United Nations Charter, that charter which was started in these very buildings, and that's why we believe there is an absolutely clear and unequivocal case for a mechanism to hold Putin and his inner circle to account. Of course, we can look at those other tribunals that have been created. We can look at those other processes, each of them, and I'm sure we'll go through the extensive pros and cons of each of the models and their weaknesses and strengths throughout the course of today. But fundamentally, this comes down to political will. It comes down to, as I said, that creativity, that innovation in legal and judicial processes to deliver justice and accountability for Ukraine. And obviously, the ICC process, whilst important, cannot fulfill the fundamental task which we're talking about today. So, as I said, we are fully supportive of a special tribunal. We're fully supportive of bringing together that diplomatic, political and legal coalition to ensure that one is brought about. And lastly, I think it's very, very important, not just in terms of the ultimate fight for justice and accountability for Ukraine and to hold those accountable, responsible for the aggression, but also because of the implications it will have for other critical matters. We're in a very complex debate here in the UK at the moment, and indeed in many other countries around reparations, around compensation, the implications that a decision in this case could have for those legal debates around, for example, the seizure and repurposing of Russian state assets for the use in the reconstruction and support of Ukraine, and a whole series of other matters, including further sanctions and further measures, could also be in part part contingent on decisions taken in these type of processes. So we must see this as a holistic whole, as a holistic fight for justice and accountability. And lastly, that urgency that was referred to by the ambassador, by the minister and others, is fully understood here. I worry that sometimes we get caught in the, and not to denigrate my legal friends, but sometimes in the cautions of government legal services and others, which are absolutely right and absolutely proper, but that those sometimes can tear us down into mere sort of academic and theoretical understandings of matters rather than the what one's called the fierce urgency of now. And that urgency of now is very clear to me from what I've seen in Ukraine, what I see when I speak with Ukrainians every week. And it's why we will continue to support this fight for as long as it takes.
Thank you very much to each of the panelists for being so clear and also being so disciplined on time. So we have quite a lot of time for questions and answers from the panelists. But just before I turn it over to you, perhaps I can pose one or two questions actually to the panelists. And maybe if I could start with Alison. So going back to what you set out for us in terms of the definition of the crime of aggression, one of the things that you talked about is that it's a leadership crime. And broadly speaking, who is responsible for this crime? So who exactly is in the frame for the purposes of this crime, and how is this different from the situation with regard to war crimes and crimes against humanity?
I think that's a really good thing to just briefly focus on. Starting with the second part of the question, so what's the difference? So if you look at war crimes, if you look at crimes against humanity, an individual soldier can commit a war crime. A lower level soldier can commit a war crime. And indeed we see there have been arrests, there are ongoing prosecutions in Ukraine. And the reason for this is that war crimes, crimes against humanity is a slightly different case, but broadly the same holds true. War crimes, the Rome Statute draws on the Geneva Conventions, and they were designed so to constrain the acts of soldiers on the ground as well as the leadership. So essentially one is looking at acts which violate the Geneva Conventions, acts which violate the definition now in the Rome Statute. They can be committed, and are committed by individual soldiers. The challenge in those cases is going up the chain to the leadership, and the Rome Statute and the guidance surrounding it has worked hard to define what they call modes of participation. So you're actually working up from the wrongful acts on the ground, from the harming of civilians, from the sorts of terrible things we see at Bucha. They are committed by soldiers on the ground, and you have to work up. The challenge is getting up the chain of command, so you also identify higher level people, and they can be at any level of the chain of command, as long as they have a relevant mode of participation. So they've directed, they've controlled, they've instigated those wrongful acts. Crimes against humanity require, as one of the elements, a widespread and systematic attack on the civilian population. So there's an element of direction by the state. There's no requirement that that be at the highest level. And obviously then underneath that sort of umbrella requirement of a widespread and systematic attack, you have the individual wrongful acts that are directed at the civilian population. The difference with those sorts of offences, which as we can see, you can go for everything from the people on the ground to anybody up the chain of command who was in a position to direct, to control, to instigate the wrongful acts. With aggression, there's a definition in the Rome Statute, and again, this is very similar to what we saw at Nuremberg, although I think tightened up. I don't think that actually all of the 12 Nuremberg convictions would necessarily, it's an interesting question whether they would qualify under the Rome Statute, but Article 8 bis now speaks of, as I said, a person in a position effectively to exercise control over or to direct the political or military action of a state. So you can't be an individual soldier on the ground, can't commit aggression. You've got to be able to direct. There's obviously a lot of debate in the work that led to that provision going into the Roma Statute, a lot of work on what that is. Did they consider defining certain roles in the state and listing them? And the reason they didn't is because the structure of states vary very widely. So you may have a very authoritarian state, as we see in the case of Russia, for example, where there's very tight centralization of power. You may, on the other hand, have a state where power is much more diffuse. You may have a state which is chaotic or fragile or less organized. And so they didn't want to sort of tie the hands of the ICC in looking at that. But we are talking here, we're talking about not soldiers on the ground, we're talking about people who essentially either run the state or run the army to a level where they can actually decide about the deployment of forces.
Thank you. And I had one question for Anton before we go to Q&A. It's actually a question that follows on from something Stephen Doughty said, and he talked about the urgency of the now, you know, and the importance of moving forward. We're going to talk in panels later on about the different models, and we'll get into some of the legal debates, but I actually was thinking about process. So how do we get from where we are now to where we're trying to get to? I'm not asking you to look in the crystal ball, but at least tell us a bit about what has been happening in terms of process to try to create this tribunal.
Thank you, Dapo. I mean, I'm of course agreeing with my colleagues that one of the key issues is political will. Because whenever the political will is there, we will need not much time to make the case working. I mean, this is a tribunal for one crime. It shouldn't be a very complex machinery, so I'm sure that whenever we find the landing zone, we really won't need a lot of time to prepare it to be functioning. And as of now, we really made progress in, I would say, preparation to getting this final decision and to launch the process. So as I mentioned, we have now a core group of 40 states, which meets quite often and discusses all the legal and technical issues and challenges in relation to the establishment of the tribunal. We believe that having such a group is a real value, because this is for the first time, I think, in many decades that we discuss the real perspectives of establishment of a tribunal for the crime of aggression. This has never happened after Nuremberg. Another very important interim result is that since July of 2023 in The Hague, the International Center for the Prosecution of the Crime of Aggression against Ukraine, the ICPA, began to function within the premises and location of Eurojust, within the framework of joint investigation team of Ukraine and several other European states. So ICPA is a communication and coordination platform which is to assist prosecutors in communicating and exchanging of information in relation to prosecution and investigation of the crime of aggression. So ICPA may be seen as a real value because, again, this is the first time in history after Nuremberg that international investigative initiative is there, supported by the European Union, and that the ICPA is a very important step towards tribunal because investigation, prosecution, then the trial. What we also have, and it is important, we have good political support on the level of national parliaments from parliamentarians, as we see just now also, in the form of resolutions, in the form of communiques, in the forms of declarations of Parliamentary Assembly of the Council of Europe, European Parliament, Parliamentary Assemblies of NATO, OSCE, and national parliaments of Ukraine and other states. In Ukraine, we also have established this working group, which Mr. Smirnov leads under the Office of the President, and also there is an interfractional unit in the Ukrainian Parliament in Verkhovna Rada of Ukraine, which unites members of Parliament from all the fractions. So it is also not a matter of division in Ukraine between MPs. Everybody understands that this is a priority and this is a very important issue for our whole country. So I think that this is where we are now. We are discussing some particular options how to do this. And I think that I would reiterate myself that when we find out the solution, when the solution would be applicable, would be effective, I think that we will not spend a lot of time in implementing it. And one more issue which I wanted briefly to flag on is that it is really very important that the Russians' actions get legal assessment by the courts and tribunals. Of course, resolutions of international organizations, they are very important. But it is important that we have courts' judgment and decisions on illegality of Russian actions, because this is something what forms a portfolio of Russia as a violator of international law, and Russian citizens and Russian leadership as international criminals. And you know that just yesterday in the International Court of Justice in The Hague, for the first time, Russia was declared as a violator of international law, having violated both International Convention for the Suppression of Financing of Terrorism and International Convention for the Elimination of Racial Discrimination. So we do believe that this is first step, which will also, galvanize, which will make all the other processes on legal track against the Russian Federation more effective and faster. Thank you.
Okay, thank you very much. Why don't I bring in those of you who are in the audience? I don't know if we have microphones available. So if you just put up your hand and you'll get a microphone. If you can introduce yourself, that would be useful. Keep the questions or comments brief. Yes.
Hello, I'm Devika Hovel from the London School of Economics. I hate to be the prosaic, pedantic lawyer in the room that Stephen Doughty quite rightly said often get in the way. But I just want to raise a very legal question of jurisdiction. And the reason I hope Stephen Doughty will continue listening is because jurisdiction, though it sounds very boring and legal, is about political authority. And coming back to Richard Goldstone's point, political will is at the base of this tribunal, political authority more so. So I just wondered whether the panellists could speak a bit about who they think gives this political authority. I wonder whether here, and I'm really interested in our Ukrainian colleagues, that it seems to be they are distancing themselves from the idea of a hybrid tribunal towards more an international tribunal, because it's the international community that needs to give authority to this tribunal, certainly in order to avoid immunity questions, for example. I just wanted to get very legal, perhaps for our lawyers, universal jurisdiction. I wonder whether this is the basis that has to be the foundation of this tribunal. Thank you.
Okay, so who gives authority to these tribunals and where does it come from? We're going to have a panel later on about the different models, and maybe the answer will depend on the models. But if anyone wants to take that, Justice Goldstone as well, but anyone who might be interested in that. Alison?
I mean, I agree that that's a vital question, and we can draw some conclusions from, for example, the ICC has been set up by a multilateral treaty where states have, and there's actually nuanced debates about what did they pool? Did they pool their own individual authorities and jurisdictions and national jurisdictions plus their extraterritorial jurisdictions to build together the jurisdiction of the ICC? But I think that given, and all the discussion is that given the blockage of the Security Council, which of course is the ultimate source of mandatory authority in the current architecture of international law, what sources of authority can one draw on, I'm not going to say less than that, but separate to that organ when it's blocked. So for example, the UN General Assembly in its acting under the Uniting for Peace procedure, which was specifically set up to be triggered when the Security Council was unable to fulfill its mandate of for protecting international peace and security. How much of this, in that specific situation, how much of the mantle of authority of the Security Council can the General Assembly pick up? That's a very interesting question. What about what level of authority can states create if there's a, for example, widely ratified multilateral treaty specifically setting up this tribunal along the model of the Rome Statute? There you have, as you say, states pooling. Potentially the analysis is they pool their own national jurisdictions, they pool their extraterritorial jurisdictions, and they create a body where the hope would be that it would fulfill the criteria for an international tribunal, as the ICJ would see it in the arrest warrant case and other cases, so as to, crucially, rise above the level of immunity and to draw on that level of authority.
If I may, from our perspective, I think that this is both a legal and political question. Of course, legal, because we understand that any court should have jurisdiction. And here I think that whatever the format, whatever the model of the tribunal may be, we see the clear basis of jurisdiction that this crime is committed on the territory of Ukraine. So if Ukraine participates in some kind of a partnership, as Justice Goldstone called it, so, and then this jurisdiction comes through from our soil, I think that this is reasonable ground. But I also think that this is more than a legal issue, because for us it is important that this tribunal should not be seen as only Ukrainian response to the aggression. Because then it is like, you know, for what we are working together on this accountability track. So it's important, you know, in our Ukrainian courts, each and every Ukrainian court starts the judgment, the decision in the name of Ukraine. So it is important that this tribunal does not proclaim judgments in the name of Ukraine. So it should be international effort, it should be common effort to tackle this crime of aggression. And I think that this is crucially important. And that is why it cannot be also vested to the Ukrainian judicial system. It cannot be part of it. It should be a sole standing court. And of course, the issue of immunities, the part and parcel of this discussion.
Okay, let me take another question. Yes, right here in the front. If you remember to introduce yourself, please.
Thank you very much. I am Petra from Embassy of Slovenia here in London. First of all, I would like to thank all the speakers of the panel and the speakers previously for your inputs. Slovenia is a big friend of Ukraine. We are helping out with humanitarian aid, military aid. We also welcomed many Ukrainians to Slovenia. We are a staunch supporter of rule-based international order, and we are participating in the discussions around the formation of the tribunal. We are in favor of the tribunal with broad international legitimacy. And my question is, I guess, for you, Dr. Kurinovich, about galvanizing support. So we heard the importance of political will, that political will lies in the core of it. And what I would like to ask is, how can your friends help out more? What do you need for us, be it in New York, in the United Nations, and if you see any other international fora that would be appropriate for galvanizing support. Thank you.
Thank you so much for your question. And of course, we are really grateful to Slovenia's support, and we are very happy to work within the framework of core group with your legal advisor. And we are happy that this month there will be the signing of Ljubljana, the Hague Convention. So, I mean, this cooperation does have a lot of different vectors, and this is really great. In relation to how to make this support more effective, more broad, how to galvanize it, I think that what we have already achieved, and this is good, that, I mean, pretty much all the European Union member states are participating in the discussion, and I want to praise our colleagues from EU for making this happen. It would be really good if we can take this discussion out of the region. So it will stay here in the region, we are sure of that, but to include more states from Latin America, from Asia, from Africa to this issue, because in the very end we will need this broad support. Whatever model, whatever format will be chosen, we will need broad support in this or that way. So I think going to the regions which are still not so much included into the discussion would be really important thing, and of course we are happy to work together. UN New York is probably the best platform for doing this, but if there can be other ways, bilateral, multilateral, we're happy to do this. Thank you.
I was wondering if I could turn that question also to Stephen Doughty.
Yeah, sure.
What can other states do?
I think there is a critical role here for parliamentarians and legislators. You know, certainly, I mean, in all of my travels around Europe and North America, which is the brief that I hold, I'm discussing Ukraine on every single one of those trips with everybody, governments, oppositions, and indeed in all aspects, whether it's military support, whether it's justice and accountability processes, whether it's that broader diplomatic coalition. And actually the role that Ukrainian MPs, indeed of all parties from the Rada have played in this is crucial too. And the more that we can get them out and telling the reality and the story to their parliamentary counterparts around the world. I've got friends in the Rada who've been in Africa, in Latin America and elsewhere, and obviously they have their responsibilities at home, but sometimes they are some of the most impressive and crucial advocates in telling the reality of what's going on and why they need support. And it's that person-to-person contact that can help. In a completely different context, I was just in Washington a few weeks ago meeting with Democratic and Republican Congress people, both about the direct military support, but also we were looking at different legislative mechanisms for the seizure and repurposing of Russian state assets. So I was meeting with Congressman Lloyd Doggett, who has been leading a bipartisan bill in Congress on the seizure of assets, which of course is another very complex legal question that we're all grappling with at the moment. So that cooperation, I think, is critical in terms of sharing ideas, sharing perspectives, but building that diplomatic and political pressure.
I wonder if I can just add a short point. I think it should be recognized that the International Court of Justice especially recognized the International Criminal Court, the ICC, as an international court. And it's important to recognize that the ICC is a court that exists outside the UN. It certainly cooperates with the UN and there's a relationship, but it's not a UN organ. And also it's important to recognize that the United States, Russia, China, India, the four largest countries by population, are not members of the Rome Statute, but that does not prevent the ICC from being an international court. Thank you.
Thank you very much. I'm afraid we have to draw this panel to a close because we are out of time. It just leaves me to thank the panelists very much, and thank you, Richard, as well. Thank you. Please.
Thanks, everyone. I'm loath to interrupt such a fascinating discussion. Thank you very much to our panelists, Dr. Koreniewicz, Ms. MacDonald, Mr. Doughty, Professor Akande, and Justice Goldstone. Now there's a brief break for coffee, so please do go back into that room that you came through earlier this morning, and be back here at 11:30, please, for panel 2, which will look at potential models for the Special Tribunal. Thanks very much. Just to note to all of you, that clock is about 10. And yeah.
Or I can start also from here, like that talk. Or you start from here.
I'm going to introduce you, then I'll disappear. You can start here, but you'll need a microphone.
Yeah.
Is there someone from AV who can help us with the mic, please? Thanks. All right, welcome back, everyone. We'd now like to introduce panel 2, which will discuss potential models for the Special Tribunal for Ukraine. I'd like to introduce, first of all, our moderator, Jörg Palakiewicz. He is the director of the Directorate of Legal Advice and Public International Law for the Council of Europe. We're also joined by Mr. Richard Hermer, KC, barrister at Matrix Chambers and leading expert in public international law. We have also Ms. Oksana Loratavyova, Director of the International Law Department for the Ministry of Foreign Affairs of Ukraine. We're joined also by Gemma Doyle, Senior Managing Director at FTI Consultant, former Labour MP and former Shadow Defence Minister. And finally, we're joined by Mr. Frank Hofmeister, Director and Head of the Legal Department at the European External Action Service.
Thank you for this introduction, and it's a real pleasure for me to be here in London. And before opening the panel, I just have to recall also that London, in fact, is a very special place for someone coming from the Council of Europe, because not only were the agreements that paved the way to Nuremberg trials, the definition of the jurisdiction of the court, they were negotiated here and signed, the London agreements, but also a couple of years later, only the statute of the Council of Europe, only a kilometer away in St. James Palace. And in our context, I just want to cite one preamble paragraph where the then democratic nations that signed up to the statute formulated, convinced, and I quote, that the pursuit of peace based upon justice and international cooperation is vital for the preservation of human society and civilization. And I think these words should inspire us up from today. Our task today is to discuss models, and my idea is to keep this panel not as 4 or 5 singular interventions, but more as a conversation, I hope, with interaction between the panel and finally also questions from Q&A from the public. Our task is to discuss models, and we heard already in the introduction, there is this famous dichotomy, internationalized tribunals, and you can kind of categorize all existing tribunals so far into one of these categories, but my personal opinion has also always been that this is not such a black and white, yin and yang dichotomy, but there is a certain fluidity, and you can have a blend of international and national elements. And in fact, you have to find a solution for each specific context, and decisive is political will, as was also said already in the first panel. So my first question to the panelists is in fact, even over and above these models, what are for you the essential features that a tribunal, a special tribunal for the crime of aggression should fulfill in terms of legitimacy, jurisdiction, and effectiveness? I don't know, shall we start with a political view and then come more to the lawyers?
Sure.
Gemma, you want to start?
Happy to, and a really, really important question. From a political point of view, it's obviously vital that whatever model it is has broad international political support. And I think there is, that does exist. But whether it exists for particular models is where I think things get more difficult. We were discussing earlier, before we started, the challenges of doing this through the UN, and I think those challenges really are very real. We've seen, I think, more positive indicators through the Council of Europe and, of course, from NATO. And the ideal situation is that whatever model and whatever procedure and process is alighted on gets the broadest international support from as many states as possible. However, as I said, that is quite challenging. I think there's two main reasons this year in particular why that is challenging. One, because of the sheer number of countries who are having their own elections this year. And so attention and focus, understandably, with those different states is often on their own domestic and internal political situation. So I think all the work that's been done so far is really important because I think it will be harder as the year goes on to get the right attention and support and focus for this. And the other really big challenge and problem, of course, is a potential re-election of President Trump later this year. And so I think we have to have the discussions in a context that means even if there is not support, which eventually comes because of a Trump from America because of a Trump presidency, then there would still be a legitimate method and model which could be taken forward.
Yeah, who else? Ukraine's position is, of course, crucial in this context. Oksana?
Yes, thank you, Jörg. And let me start with thanking the organizers for this conference. It is a very important event, and the timing is also perfectly found, because now we are discussing the issue of the Special Tribunal already for 2 years. And the discussion goes, and now it is the right momentum when we should come closer to the finalizing of the discussion and taking decisions. I'm here like the representative of the Ministry of Foreign Affairs, but also I am Ukrainian. And I would like to start with saying that while talking about the model, we need to understand not only legal challenges, but also we need to think what people of Ukraine need. Because I'm civil servant, and the word servant is crucial in this. We are serving Ukrainian people. And what Ukrainian people need, it is justice. It is justice for what has been happening throughout these 10 years. Every day we have a huge number of losses, both civilian and military people. And whenever we have a massive attack, Ukrainian people say, we need justice. We want Putin to be on the trial. They don't care so much about the money or any kind of other satisfaction. But what they need is justice. They need to see that what they suffered, people who did it, they will be, first of all, in jail. And actually, yesterday's decision of the International Court of Justice, when the court found Russia guilty in violations of International Convention on elimination of all forms of racial discrimination and the Terrorism Financing Convention, is the first sign that international law and justice are on the side of Ukrainian people. And that's why we need to find the model that will meet the demands, namely the timing. So Ukrainian people cannot wait for 30 years more for Putin and for leadership, both political and military leadership of the Russian Federation, to be found guilty for the crime of aggression. Also, it is not only the crime of aggression against Ukraine, but it is the crime of aggression against all civilized world. And that's why reply should be also international. Ukraine is very grateful for all the support by all governments who are supporting us with financial aid, with military aid, those governments who help our people who are now temporarily staying in their countries, but also the support for justice and accountability should be also international, and the tribunal should rule not in the name of Ukraine, but rule in the name of international community. Thank you.
Just one additional question. I think what is quite important from the legal point of view, there are certain conditions, or also from Ukrainian law, but I think there is also a very strong point, which is namely that basically you have jurisdiction over, including Putin, you have jurisdiction over crimes, including the crime of aggression committed on your territory, because you have this provision in your criminal code, which in fact dates back from even Soviet times to some extent. I understand it's broader than the Rome Statute, but it is there, and it is in principle applicable. Procedures are being done as by the prosecutor in Ukraine. Can you maybe elaborate how this aspect, this undeniable territorial jurisdiction of Ukraine, can have a role in the setting up of the tribunal, or what are there any opportunities, constraints from that side?
So indeed, we do have jurisdiction over the crime of aggression, and actually the definition in the criminal code of Ukraine is quite broad. And we started this investigation back in 2014, and as of now, the Prosecutor General Office investigates about 800 cases. But the main issue, of course, we can charge Putin in the district court of, I don't know, maybe Mykolaiv, or another small city in Ukraine, or even Kyiv or Kharkiv. But the war that Putin launched, it is not the war of Putin against only Ukraine. It is the war of Putin against the international order. And the reply to it should be not only Ukrainian, but the reply should be from the world.
Yeah, and there we have, of course, these famous models. I don't know who wants first, Frank or Richard.
I've got the microphone, so I get a head start. Can I just start by following what you said, because it's a bit prosaic, but it's very humbling, and for sitting here in London to be asked to give an opinion as to what Ukraine should be doing to seek justice. I mean, I'm sitting in a literal and metaphoric armchair in a city that is safe. But I think it appropriate, not only because Ukraine has invited members of the international community to contribute to the thinking as to what accountability might look like. But because, of course, if you said the crime of aggression is a crime against all the international community, and we all have a role both legally as a matter of high principle to uphold not least Article 2 of the UN Charter, but I think also pragmatically, as you've also raised, because the absent accountability for this act of aggression, the consequences for the international community are so grave. To answer the question, I think there is there's some sliding lines between what is legally effective and what is politically possible. And there are very few points along those lines that meet. So what's legally ideal would be the ICC to have jurisdiction. That's not going to happen because of the task that would require to amend the Rome Statute. What would be following on from that would be a separate Security Council mandate operating under Chapter 7. That's not going to happen for obvious reasons. I also think we need to be much more realistic about the prospects of the General Assembly stepping into the breach in today's world, and that might be something that we can discuss. At the other end of what is possible, you get solutions that are legally questionable from some aspects. So if it were to be, for example, a matter that was done solely within the Ukrainian municipal legal system, domestic system, I think that would raise problematic issues, firstly in respect of immunities, and I think that's a real issue, not least if ever awards on the back of findings are ever going to be sought to enforce overseas. I also think it's a major issue in terms of legitimacy of the process for crimes in international law. And so the sweet spot, and it's something that we can discuss, to me, seems to be a form of a tribunal founded by multilateral treaty. And that should have two, to my mind, key features. We can talk about the details. But the key features is that it, firstly, that it operates to the very highest standards of international fair trial procedures. And the second is that it is complementary to the work of the ICC, and at all times is conscious that nothing it does prejudices the job of the prosecutor. And that is my worry about any of those models, because the international community, not least the international human rights community, having fought for generations to establish that court, that nothing should be done to undermine it.
Yeah, I think there practically all international lawyers agree we must avoid whatever is set up for Ukraine must not harm what has been achieved with the ICC. And I think this is very crucial. But on the other hand, it's obvious what we heard already in the first panel, the ICC cannot really prosecute the crime of aggression in this particular context. So what are then other possible models? Frank, the European Union has even also certain experience with a very particular case maybe, but in the end all cases are a bit particular, the Kosovo chambers. But what are your thoughts about models? And maybe you can elaborate on the Kosovo chambers that were established.
Yeah, thanks a lot, Jörg, for your kind introduction. Let me first start by announcing a good news. I represent here an EU institution, and we have the European Council currently in Brussels, and it appears that the leaders will agree on 50 billion additional support for Ukraine for the next 5 years. Big breakthrough, so let's start positive. Next to the military and financial assistance, the accountability is very high on Brussels' agenda. I don't want to bore you too much, but if you screen through European Council conclusions, you will find a regular topic, including on the need to punish the crime of aggression, and more recently also supporting the work of the core group. So we have really at the top political level a mandate as civil servants to make efforts to go forward. And on that note, the first tangible result was already mentioned by Ambassador Korinevich, and I'm grateful for him. That is the fact that the EU has decided to support the national investigations on the crime of aggression. So those states who currently, on the basis of their national code and universal jurisdiction, have prosecutors in action, they can meet and discuss and coordinate in The Hague under the roof of Eurojust to build up a strong case together with Ukraine. So that's ongoing, and this is part of EU support action in very concrete terms. And now the big question is, how can we make sure that this good work is not wasted, but will be brought before a competent, legitimate, effective international tribunal? For that question, you've asked me, Jörg, is that possible to look at the Kosovo's chambers? Well, on this one, I would like to caution a bit. Kosovo Specialized Chambers was a decision by the Kosovo institutions, but under the very strong guidance of the European Union, which was present in Kosovo with a special civilian mission, EULEX Kosovo, which took over from a UN mission, UNMIC, and where there are special powers vested on this civilian mission. And it does not look at the crime of aggression, it looks at war crimes during the Kosovo fights. So we have there a specific historical situation which was tackled in that way, and therefore you cannot simply put this one by one. But what you can learn from the Kosovo example, and that's I think important, is that in order to increase legitimacy, it is good to have international judges, international staff, highest level of due process. So the Kosovo Tribunal applies international law and Kosovo law, so to make sure that we are really standing together. And this is something which at the technical level, we have already, looked very detailed. In the EU, when it goes from the politics, later on you have all these various working groups, yeah? And then there's one working group on public international law where the legal advisors of the 27 meet. And there we already agreed last year on a paper, international elements of any tribunal, irrespective of the model. And that paper importantly says international judges and staff, and even more importantly, no functional immunity. So nobody who would be before the bar can claim, you know what, I'm not personally responsible because I just did what my state expected me to do. I was acting and making state action, functional immunity. We can never accept that it is a part of an ordinary state function to bring aggression towards a neighboring country. And that is a very clear position of all EU member states, although in the International Law Commission, the thing is not so clear as I just stated. So I think on this one, the EU is really pushing in the direction to have an international tribunal which would be effective and legitimate on those accounts.
Yeah, thank you, Frank. And indeed, I think both from the core group, but also discussions of the legal advisors, both at EU and Council of Europe level, they are clearly emerging kind of building blocks for any tribunal. It is now more, it's a matter of, in the end, what we heard, political will, but also to put these things together. I think any kind of tribunal, we need an international agreement, which can be either multilateral or bilateral. There have been some tribunals created with bilateral agreements, for example, the extraordinary African chambers, it was even a regional initiative, or the UN has also made an agreement with Cambodia to create the special chambers in Cambodia. So I think there are a variety of models. And the question is also about the different actors. We heard the UN is difficult. EU is very supportive, but has not a real competence. So there is also, in the end, the Council of Europe, which has a broad pan-European mandate. A statute that I mentioned in the beginning is excluding only matters of national defense. And we have a track record, after all, of associating also non-European countries to our activities, be it in the area of cybercrime or other treaties. And most recently, we are the organization that expelled Russia and that created also Register of Damage through a relatively unorthodox procedure, which can probably not be used for a tribunal, but still, the Council of Europe could perhaps be a platform, perhaps even a partner of a bilateral agreement. There are some authors, Anne Peters from the Max Planck Institute, have suggested such an idea, which is unprecedented. This is for sure. So there is a lot of work to do, but what is also your reaction of a possible role of the Council? Maybe Oksana to start.
Thank you. So let me start with thanking the Council of Europe for the support, and especially throughout these the most difficult years in the history of Ukraine. And thank you for this suggestion to elaborate more with the Council of Europe. And of course, we're thinking about it, and we are trying to find the legal mechanisms to cooperate with Council of Europe or any other organization. But we need to meet the goal that we are setting to ourselves, to ensure the creation of a legitimate tribunal. Saying legitimate means two words for us. First is that it is legally absolutely clear and fair, so that we would ensure that nobody can challenge the decision of such a tribunal, saying that it doesn't have legal grounds to be created. And second, what we understand when we say legitimate is it should have broad support by countries all over the world. And of course, we're working now to ensuring that we get support from Global South and other countries, not only in Europe. Thank you.
Yeah, no, this is for sure. It cannot be a purely European solution. Whatever is done in Europe should seek broadest international support. And but how to achieve this? Yeah, maybe from a political point of view, Gemma, you have any ideas?
So, I mean, I think what we heard was that in different situations there have been different solutions, and I think that's a good lesson to hang on to. That there doesn't have to be just one way that we address these situations, these wars, these conflicts when they arrive. So at any given time, whatever the solution that seems like it will work, I think is the one to hang on to. And what politicians want above all else is for people to bring them a solution that is as worked through as possible. And I think there's obviously been a lot of people have spent a lot of time already trying to work through this and iron out the various problems, because it obviously isn't, if there was a simple way to do this, I think we would already have been there. So I think if it's the Council of Europe that is in prime position to take this forward and for support to be built around that, then I personally don't really see any problem with that. But as I say, it's about bringing solutions which are ready to go, as it were. And I think I'm a little bit more positive listening to Frank about where things are at the moment. And I would just urge that as much as can be done as quickly as possible is done because of those reasons that I set out at the beginning. And you don't want to lose that momentum when, as I say, later on in the year, I think many governments will look inward more than outward, unfortunately.
Yeah, I think what is really important, I think the function of every court is not only to do justice, but also making justice seen in a broader, not purely legal, but even moral or historical sense. And so we need an international tribunal. It cannot be, even if it is based on, to some extent, on territorial jurisdiction of Ukraine. And I think it's an important element also to avoid the reproach of retroactivity, retroactive application of the law, that we have this criminal offense in the Ukrainian criminal code. But nothing, I think, prevents the tribunal to go also broader. As Frank suggested, I think it's a fact also under Ukrainian law, judges apply national law taking into account international law. So the standards that are customary international law are, this is what you do in Ukraine as in the UK. We had one other question before opening. I think it's also a good moment to have even then more time for questions, but we had one question about the location of the tribunal, but I think this is a bit moot because we have a very clear and public offer. The Netherlands, in fact, said whatever model will ultimately be chosen, they are willing to host such a tribunal. And in The Hague, we have ICPA, this International Center for the Prosecution of Crime of Aggression. We have the International Criminal Court. Even the Register of Damage that I mentioned that the Council of Europe established is hosted by the Netherlands. We concluded a host state agreement. So I think the Hague it will be. There seems not little doubt, or I don't think anybody here will doubt this. To do effective cooperation with the tribunal, Richard, from you as a practitioner, from your experience, what are important aspects concerning also protection of victims and in general mutual legal assistance with such an international body?
Well, I should say I'm not an expert in international criminal law trials. So I'm going to speak from a position of generality. But it all turns back to the legitimacy of the court and the jurisdiction of the court and the degree to which other jurisdictions are going to recognize the jurisdiction of the tribunal to give effect to requests for mutual legal assistance, to give effect to the recognition and enforcement of any awards that a tribunal may make if a tribunal considers the making of awards falls within its jurisdiction. And so all roads to me lead back to the kind of the precedent question, which is what's this tribunal going to look like? What's the jurisdictional basis for the tribunal? And it all leads from there. Can I just also just follow on the last question, just to give one comment, that a consistent critique of international justice over the past years has been, well, certainly since Nuremberg, the danger of being perceived as victor's justice. And secondly, since the creation of the ICC and the prosecutor's choice of cases to bring, that it's Western justice. And I think, as the other speakers have commented, it is essential to the legitimacy of any tribunal that the Global South play a full role, that it is applying in the international community insofar as possible, applying and upholding international law. So whilst the role of the Council of Europe may well be central and important, and speaking as a Brit who's currently facing all sorts of moves to distance ourselves from the Council of Europe, which would be the most retrograde step imaginable. It can't be a bilateral treaty, I think, for this to work with the Council of Europe. It's got to involve centrally the Global South.
Yeah, no, not to be misunderstood. Whenever what I meant with Council of Europe role is not that the Council of Europe is setting this up on its own. This is not, I think we need, what you say, the broadest international support, but even getting support from the international community can be helpful to be anchored in a certain structure instead of having something totally freestanding. But of course, this is ultimately, these are questions of also political will and expediency. I don't know, before opening to the public, Frank, you maybe on these issues, international support, legitimacy, UN, all this, some thoughts?
Yeah, well, I can only echo what Oksana said. It is important to reach out, to convince that this is not a Ukrainian issue, that it's not a European issue, but that this is something which concerns the breach of a fundamental rule of international law, which is a peremptory norm, which is jus cogens, and which needs an international response. I think that's clear. On the other hand, we also need to have a dose of realism, unfortunately. So when you compare the votes, there were 140 states in the General Assembly who said this was aggression. There were less than 100 who said, we recommend to establish a register of damages. And I don't know how many votes you will get if tomorrow you go there and say, let's punish Putin. So if you tomorrow go to the General Assembly with such a resolution and you will get disappointing result, the whole exercise is dead. It's a recipe for failure. So I'm not a politician. I can only say, please be realistic of what you can achieve with such an exercise. Therefore, I have more sympathy to what I understand Ukraine is now doing, is to have bilateral contacts, to get more and more people convinced that this is a good idea, to be part of a joint exercise of whatever common solution will come out of that. That's a little bit my observation from the sideline.
Yeah, no, I fully agree, and I can cite a politician. I mean, he spoke to the core group, but as a politician, I think he can be quoted. We had the last meeting in Luxembourg, and we had the Deputy Prime Minister and Foreign Minister Xavier Bettel, who opened the meeting. And one of his remarks was precisely in this sense, saying that a failure, now go to the UN and have a failure on a vote on a tribunal, this would be the biggest victory for Putin. And after all, we have this vote that aggression was recognized by more than 140 states. So in whatever, I think in whatever formation, coalition of the willing we go ahead, it has legitimacy in this sense. But we have to somehow combine realism with legal, with legal intelligence. But with these words, I think it's time for opening up to the audience for questions.
Yeah. Is that all right? I can just shout if that's better. Any better? It looks like... Oh, there we go. So, my name's Jack Sproson. I'm here on behalf of the Reckoning Project today. I just wanted to tease out this notion of legitimacy a little bit, and it really goes back to the start of the conversation when we were talking about the broad support from around the world. And I wonder if we're playing a failing game if we say we need more and more and more and more, because if you've got 40, okay, so if you get 80, Is that enough to be legitimate? Is 120 enough to be legitimate? Is 140 enough to be legitimate? And I wonder if there's a risk that we face focusing on who hasn't supported rather than who has. And so I think this has already been got at under the surface, but I wanted to tease it out. Is the idea perhaps better to say that breadth is better than depth? If we can pull from different continents around the world, maybe with fewer but more broad, is that more legitimate? And that's just something that occurred to me, and I thought perhaps good to get the panel's views on.
Yeah, Richard, you...
Well, I think legitimacy can mean different things. There's legal legitimacy and there's political legitimacy, and hopefully what you want to find is something that those two match completely. But as I kind of outlined at the beginning, that from a legal perspective might not be possible because your hard-edged legal frameworks are the ICC or a Security Council mandated tribunal, and you're not going to get that. And so you then come into, from a legal perspective, slightly uncharted waters. I mean, you've got some examples. Sierra Leone was Security Council mandated, but you've got some other kind of hybrids. But effectively, you're in difficult legal territory for the terms of the question as to whether or not, for the question of immunities, for the question of enforcement, etc., etc. The political optics are different. And so there's no magic number legally outside the frameworks, I don't think. The more, the better, the stronger the argument. And I think that does reflect the politics as well. But again, and I think you're right, from the political perspective, it's as much who is signing up as the precise number.
Jim?
I completely agree with the premise of your point, and I agree that if we're playing a numbers game, I worry we'll be very disappointed. So in a sense, this is a very imperfect answer, but I think we will know what what legitimacy looks like when we see it. And that is a massively imperfect answer and situation to be in. But it's why I would say that we may not find the perfect solution which everyone feels is happy, and Ukraine does have to be happy with it. They are the people that have to be happy with it above all else, of course, because it is about delivering justice. But I think, coming back to the point before, it's about what can we make happen that achieves something, not in 15 years' time, but as quickly as possible, that does feel like it gets to some sort of resolution.
Yeah, I would echo that there is no fixed number to be achieved. We just have historically two numbers. The one is there were 4 states who signed the London military agreement on the Allied powers on Nuremberg, and there are 120 who are currently state parties, but 60 were sufficient to bring this into motion. So if we have now 40 core group states, I think that's already pretty good.
And I would like to come back to the issue we discussed a bit earlier, is that this crime is not against Ukraine, but it's against international order. And that's why with the support for international order should be really international, and have the number of those who support it. 40 is good, but 80 would be better.
Yeah, another question.
Thank you. Vlagalushka Open Society Foundations. I actually have 2 questions. One for the representative of the Ukrainian government. In your strategy to reach to the global south, how do you approach democracies versus more authoritarian regimes? Because I would say that democracies would probably be more open to support something like that because they just generally care about the rule of law inside and outside. And the second, I think it's the question for kind of foreign representatives. I think we're trying to partition the issue of Ukraine establishing this international tribunal from other global justice issues. And sort of the task then is on Ukraine to do that. But inevitably, how other countries behave toward other justice issues, to name one, Israel-Palestine, the action by South Africa, matters for Ukraine a lot. So, I mean, like, Ukraine can go 20 rounds to every single country in the world, but if the position of Western countries on Israel and Palestine is such that the global South finds it unpalatable, these efforts are futile. So I'm just curious about your feedback. Thank you.
This was direct.
Thank you so much. Of course, I will not now reveal diplomatic secrets, how we communicate with our partners. But what I can tell you that we do face this challenge communicating with Global South. First of all, because there is a huge Russian presence there. Russian money are there. A lot of Russian diplomats are there. But the strategy, diplomatic strategy of President Zelensky and President Kuleba, and Minister Kuleba, is to reach them. And we have a special strategy of communicating with Global South. Minister Kuleba already had a number of visits to African countries and to Latin America. And it is very high on the agenda of Ukraine to communicate with them. We have special communication strategies, diplomatic strategies. We're doing our best.
Yeah, I think the question is very important, and it's, I think the countries in the south, they sometimes see it as a purely European war and precisely accusing the European countries not to use the same standards for conflicts in Africa and now also in Israel. And I think this must be addressed, this issue. I think for Ukraine, it's important to argue really what we see with the blatant aggression there. It is, after all, an imperial aggression. It is your history. It is true, even myself, in Western Europe, we had a long time this idea the Soviet Union is all Russia and it's all just a unitary state, overlooking that there are so many peoples, and some of them were more or less came into this empire not exactly through the will of the people, and in this sense, there should be quite a parallelism with the anti-colonial struggle that in the global South. But it's this more political issue. Maybe we have another legal question.
Hi, Jason McHugh. Really just building on what you've been talking about on developing consensus. Well, one of the issues clearly is that there's the politicization of the ad hoc nature of this being on the Ukraine. Would it not help presentationally to approach this as a more permanent structure and therefore build consensus, because it then builds on everyone in the global South have an interest in having some sort of infrastructure out there of which we all agree there's a gap, which could be used by them in the future?
Now, this is basically a revision of the ICC statute, the avenue which I think should and must be pursued in parallel, but it's maybe not a solution immediately. But Richard?
Yeah, I think not, for that reason. So aggression is on the ICC statute, and there are lacunas jurisdictionally, as Russian aggression here demonstrates, and that, I think, needs to be dealt with on an ad hoc basis, because the moment that you set up a permanent structure to deal with the crime of aggression, you de-tool the ICC. And I think that would be a critical mistake.
I would also say whatever this tribunal will do, ultimately it should feed into a future jurisdiction better formulated, not with all these carve-outs as in the Kampala agreements, but a more operational procedure. And in this, but it should ultimately be the ICC.
Yeah, I mean, when the ICC works as we all dreamed it would work, there should be no need for any more ad hoc tribunals.
Yeah, just to share a little piece of information, inside the European Union we have also looked at this. There is no consensus, but a couple of member states are taking a way forward. So in particular, Germany has started an initiative which is called the Friends of ICC Revision. And it is precisely there that the German government wishes to have support to get rid of the procedural constraints. So as explained in the first panel by Alison MacDonald very eloquently, there are special rules for aggression that only when the Security Council refers the case or when both sides have ratified, then the prosecutor can act. This is in contradiction to the normal rules that for war crimes, the prosecutor can start any time. So the solution for this is, and I reckon your point is, get rid of the special constraints and make the ICC a world criminal court also for aggression. But let's also be self-critical. Not even all of our states have ratified Kampala Amendment in the first place. So it takes time and conviction, but I think the need to look at that is clear.
Another question from the audience? Yes. Yeah. There was no, there was, yeah, there. There is in the
yeah, sorry to come back again. I just wanted to perhaps offer a question on the ICC point. I wonder if it's right to say that actually the ad hoc nature of this reinforces the primacy of the ICC, because we're saying precisely because we don't want to undermine what we've built there, we're actually finding ways in which to ensure that perpetrators who otherwise fall outside of that framework don't escape justice. And so I wonder whether that's the right way to look at it in terms of the fact that we value the ICC so much that we're not going to push it to breaking point, and in fact we're going to find other solutions. And I don't think ad hoc should be a dirty word necessarily. It's just the nature of things that we do.
Yeah, Richard? Yeah.
I've got to stop picking up the microphone early. I don't think ad hoc is a dirty word, and I think there is a legitimate lacuna created by the special rules around aggression in the Rome Statute that make it entirely legitimate and appropriate to have an ad hoc tribunal here, albeit one that I said at the outset has to be complementary to the prosecutor's investigation of war crimes in Ukraine. So I don't know that that promotes it. It promotes international justice. It promotes the principle of accountability in international justice. But I mean, I am heartened to hear that the other thing that it does is that it is spurring ongoing discussions as to closing the gap within the Rome Statute itself.
Yeah, and if I may add on a detail on cooperation, let's assume we have the ad hoc tribunal in one mode or the other. And then you would have a prosecution against, I would call, General X, yeah? General X has committed war crimes, and he had also been part of the superior structures who has waged the war. So he may also have committed aggression. What to do then? Where should the general go or end up? And I think the majority of the states looking at the question would say, there's no question he should end up in the ICC. Yeah? So the International Criminal Court is the place to be, and the ad hoc court will have to make sure that the gap is filled, but not to take the place of the ICC.
We have still question for one more question. Yeah, one more question here in the front.
Hi, my name is Victor Pomikal. I'm from FTI Consulting. We've helped to organize it, so perhaps it's a question. But I think what is very interesting here is that we keep tying the crime of aggression to other war crimes, but we're talking about a very specific crime. Is there any case law and any examples that we can follow where you have a theoretical a case where war is an unjust war, but where we are only trying the crime of aggression rather than, in addition to that, all the other war crimes?
Yeah, Oksana?
Yes. So, unfortunately, there is no direct precedent that we could follow. Of course, the ideal model for us would be if we have the decision of the Security Council. But we all understand that this will never happen. And actually, the situation we are facing now, unfortunately, is unique. So the reply should be also unique but legitimate.
Okay, then thank you very much. To quote a famous British politician, enough talking, it's time to do. I think it is really, we are on the, if I'm on the 707th day of the aggression, which has brought such immense suffering to the Ukrainian people. And we are still discussing about legal issues. It's a bit a disgrace. It's the establishment of this tribunal, I think, is really a matter of credibility for the international community, but also for Europe. After all, the war is taking place in the heart of Europe. So let's hope that this event also contributes to promoting and fostering these ideas. Thank you so much for the organization.
Yeah, thanks very much to panel number 2. The question of models for the Special Tribunal is an incredibly complex one, and I'm sure you'll all agree that the panelists today made some very impressive progress in exploring those issues. There's another expression which is enough talking, let's eat. So can everyone now go through to the room where you were having coffee earlier, where lunch will be served. But please remember, Philippe Sands will be back here at 1:30. So people will be coming to nudge you on the shoulders, but please be back here for about 25 past so we can start promptly. Thanks, and thank you all. Don't turn the mics on and off. They will control when a mic needs to be used. Cool. Do you want to give that to Mr. Sands?
Mr. Sands.
If you come up here, I'll stand.
Sure.
I'll introduce you. Everyone for coming back a bit early from your lunch. As advertised earlier, we're very happy to introduce Philippe Sands, KC, Professor at UCL, Barrister at 11 Kingsbench Walk Chambers, and author of East-West Street. Thanks, Philippe Sands. And he's kindly said that he'll talk for a brief minute, but he'll also take some questions from the floor afterwards.
Thank you very much. I'm so sorry that I haven't been able to join you during the day. As some of you know, I'm sitting as an arbitrator in a hearing. I was given an exemption between 1 and 2:15, so I've hot-footed it on the district and circle line, and I need to be back by 2:15 for the other side's opening arguments. But I've heard that it's been interesting, that it's been good, so I'm going to speak very briefly, and then maybe just to have a couple of questions. My involvement in this issue, in a sense, goes back to the very beginning. The Financial Times got in touch just after Russia invaded Ukraine again and asked me to write 700 words on Ukraine and international law. They approached me because I'm an international lawyer and because I'd written East-West Street, which is, of course, largely focused on the territory of Ukraine, Lviv, extraordinary and wonderful city. And I didn't need very long to think about what I wanted to address, which was the gap in the international architecture. We all knew the International Criminal Court had competence, had jurisdiction over 3 crimes: war crimes, crimes against humanity, genocide, but it does not have competence in relation to this matter on the crime of aggression. And as with 1939 and the Nuremberg proceedings, the statute, an agreement for which was signed literally just a few hundred meters from where we are sitting today, in the summer of 1945, the decision to go to war and the legal aspects of that decision are the sort of heart of the matter. And the heart of the matter leads to the top table, probably a dozen people, no more, of whom no more than 3, I suspect, would be able to claim any sort of immunity in relation to whatever institution is ultimately established. And the sort of nightmare scenario for me was that we get a situation in which in 3, 4, 5 years' time, you get a sort of raft of relatively junior people hauled up before the Ukrainian courts and perhaps also the International Criminal Court, but the people at the top table get off scot-free. And the thing about the crime of aggression is that it is direct. It leads straight to and only to the top table. And so it sends a very important signal. If you had asked me after the article appeared in the FT what I considered the prospects to be for such an agreement for a special criminal tribunal to come into effect or operation, I would have said somewhere below 1%, if that. But words matter, articles matter, ideas matter. I think I was joined by many other people who shared this concern, and a sort of rollerball effect began, and one thing led to another. And you all know where we are. There is essentially, for a group of about 40 countries, a consensus that something needs to happen on the crime of aggression, and indeed the European Union has already set up an entity which is gathering evidence, although the evidentiary aspects of this, I think, are pretty straightforward in terms of most of the key people. But there is a difference between 2 competing groups as to the nature of the institution that should be set up. On the one side, led by Ukraine, but with strong support from Baltic countries and Poland and various other countries, a full-on international criminal tribunal with exclusive competence in relation to the crime of aggression to be set up in The Hague, a la Nuremberg. On the other side, the G7, led in particular by, in no particular order, the UK, the US, and France, who have sort of given a thumbs up to the idea, but want an institution which is sort of more hybrid, and in particular, which is not going to set a clear precedent in relation to future tribunals of this kind being set up for other P5 members, their minds having been concentrated by the prospect that if you create a special criminal tribunal for one permanent member of the Security Council today, why can't you do it for another one tomorrow? And of course, the elephant in the room is Iraq, and in relation to France, which opposed Iraq, a certain exposure in Africa in particular, with various allegations going around. So the issue is to build a bridge between those two options. And we know that the European Union side has made a proposal to build a bridge. I've seen that proposal. It seems to me to be a very workable basis to go forward. And the context in which I say that is that for this deadlock to continue, basically only assists one side in this conflict, and that is the Russian side. The West is divided, Europe is divided, they are unable to act even on this issue. And in the shadow of Westminster Hall, where the Nuremberg Statute was drafted, it strikes me as appalling that we are not able to find a workable mechanism to build a bridge between two different views. And my reason for coming out of the arbitration is really just to send that message, to say, do it, find that bridge that allows both sides to feel that they have got what they want. The second elephant in the room is the issue of immunity. My view on that is very clear. Don't address it. Leave it to the judges to sort out in due course. That's what happened, for example, with the Special Tribunal for Sierra Leone. I just bumped into her down in the corridor, my friend and colleague, Alison MacDonald, and 20 years ago, we were asked to do an amicus brief for the appellate chamber on that issue. We formed a view. It was not an easy view to form, and the appellate chamber then went in that direction, but they could have gone in another direction. That's for the judges to sort out. So put that, I would say, on one side and find a way, whether it is by a delegated model with an internationalized aspect, to break the deadlock and do it very quickly and very simply. It's not a complex thing to do. If that doesn't work, go back to other models that we have raised, the Council of Europe model, or various other options. One of the aspects of this discussion that I find so particularly sad is that the institution that seems most opposed to this idea is the International Criminal Court, in the form of its prosecutor and in the form of some of its judges. This is not an issue of principle for them. It's an issue of turf. And it strikes me as deplorable that at this particular moment in time, when a conflict rages on the territory of Europe, of the kind that has dragged on for 2 years, and which could plainly extend into a much bigger conflict, we know that is a possibility, with a very difficult time ahead in the coming winter for Ukraine. The idea that protecting your own institution, turf, is driving your opposition is utterly appalling. I'm going to be very clear and very public about that. It is a deplorable situation. A special tribunal for the crime of aggression does not minimize the role of the International Criminal Court. Quite the contrary. It accentuates it, it highlights it, it emphasizes it, it reinforces the very significant role that it has. And the absence of a special criminal tribunal for the crime of aggression, I'm afraid, has most unhappy, unintended consequences, including the decision of the International Criminal Court to publicly and openly indict Vladimir Putin at this point in relation to a crime which, as a parent, of course, is of huge significance the forcible transfer of children, but in the scheme of things does not get to the heart of what this conflict is about. This conflict poses a most fundamental threat and challenge to Europe and to a set of values that I care passionately about that were articulated in 1945. I hope that France, the United Kingdom, and the United States, and Germany, which is sort of following whatever those three countries do, will see the light and show some flexibility. My sense is that Ukraine itself is willing to show some flexibility and find a way to build a bridge and do it quickly before winter sets in, fully and completely, or at least we break out and leave winter. This conflict is going to go on, we know, for the rest of this year. There is going to be no resolution before the United States election in November. We know why, so sort this out, find a bridge, and do it now. Let me stop and take a couple of questions that are of interest to people who've been at the meeting today, which I'm afraid I have not been at. Thank you so much for your support for this idea, and I express again my big personal solidarity with Ukraine at this difficult moment. It cannot have been so crystal clear that there's no reaction, no argument against what rubbish Sands is talking again, no points of detail. Yeah.
Hello, Philippe. Thank you very much. A lot of provocative statements there. Again, the lawyer here. Immunity. So you say, leave it to the judges. Surely, though, we need to set up a tribunal that's going to make it most possible for judges to come to that view. If that's the case, surely it must be quietly in our minds as we think about the model for the tribunal.
Absolutely, Davika. I'm sure our personal positions are not far apart on what the ideal would be, but we all know in life that very often the best is the enemy of the good. There are two opposing views on the issue of immunity. Three significant countries, permanent members of the Security Council, don't want to touch what they believe to be an established immunity rule. Ukraine and others don't want a tribunal that has no clear rule removing or stripping or determining that there is no immunity for certain people. You are not going to bridge that difference in a negotiation, period. It's not going to happen. It's just not going to happen. So the way to do it is to proceed pretty much as happened with Sierra Leone, negotiate, reach agreement, find the delegated model, have a statute, and both sides can do what they are able to do to incorporate into that statute that gives it a nudge in the particular direction that they want. It's what happened with Sierra Leone. And then ultimately it will be for the judges to decide, rather if there is a pretrial sort of chamber, does X or Y have immunity or not? It'll be for the judges to interpret the text. But there's not going to be agreement on immunity. That bridge cannot, that gap cannot be bridged. And experience teaches you that in those circumstances, rather than having the whole thing collapse, work out a text which allows both sides to leave the table believing they've got what they want and leave it to the judges. That's my personal view on that issue. I understand your position, but we're not going to get a text which is clear either way. It's just not going to happen.
Hi, Jack Sproson. I've already asked many questions, so apologies for those in the room, but I asked a question previously to a panel as to whether it's right that the ad hoc model can actually serve to, in your words, accentuate the ICC, so to fill gaps where the ICC isn't. But I'm interested in your views as to precisely why it emphasizes the ICC. I have my own views, but I'm interested just to dig into that a little bit deeper.
Well, I think I think a tribunal should be in The Hague for symbolic reasons, but also for practical reasons. I think one could imagine some sort of arrangement between a special tribunal and the ICC. One can imagine, and I think this would be a good thing, staff seconded from the ICC to a special tribunal so that the ICC is comfortable, that it is fully in the knowledge of what's happening at a special tribunal. And plainly, there are going to be overlaps in terms of the evidence gathering, and so there should be cooperation between the two institutions. And that's why I think it's so deeply regrettable that instead of saying, okay, we have an open mind about this, let's look at ways which accentuate the role of the ICC in those areas in respect of which it has competence and can exercise that jurisdiction which it has. Let's share testimony, let's share personnel. I don't know also whether it's excluded that one could not even share individuals who are involved at the upper levels. I suspect sharing judges would be difficult, but you could have a former judge or more than one former judge from the International Criminal Court who's always going to have a personal sense of commitment to the International Criminal Court. There are many ways of building coherences between the two, and I think it's something that a reasonable group of lawyers in the space of a day can work out mechanisms to ensure that the ICC is fully comfortable with what is being done. But the bottom line is the ICC cannot deal with the crime of aggression, and that is the crime of crimes in this case. And to turn your back against the crime of aggression just seems to me deeply regrettable and much, much worse. And it's going to come to haunt the International Criminal Court when the history books get told that it was a number of judges, I'm not naming them, I know who they are, and the prosecutor who turned their back on this idea. So I would invite them to reflect really carefully on what it is they are doing, because their position is not coming across as a principled position, but, if you like, as a position of self-interest. And at a time of extreme seriousness, that is really problematic. I wouldn't want to be remembered like that.
Toby Cadman, I'm on the next panel, and this is obviously something that will come up in the next discussion. Unfortunately, we won't have the benefit of you being in the room, so I thought I'd take the opportunity to ask you. You've said that for principled reasons and practical reasons it should be in The Hague or in the Netherlands. What role do you see for Ukrainian judges and prosecutors within such an institution? I asked the question because we have the Kosovo Specialist Chambers, which I will speak about in the next panel, that is not well received because of the complete exclusion of Kosovo professionals. So what role do you see for Ukrainian judges and prosecutors in particular?
I think it's an excellent question. It's a very important question. I think we can all see the advantages and disadvantages of either model. To completely exclude any Ukrainian from the process is going to go down very badly in Ukraine for understandable reason. To make it dominated by Ukrainians will raise issues as to its legitimacy and its independence in parts of the world, even beyond Russia. That would be problematic. So my own sense is you want probably a balanced approach in which there is some Ukrainian involvement. Over the last 15 years, I've come to know a lot of Ukrainian lawyers, criminal lawyers, international lawyers. There are many excellent individuals who can serve as researchers, as prosecutors, and as judges. I don't think the Ukrainian component should dominate, because I think that it's very important to send a signal out to the world that this is not, if you like, a Ukrainian hatchet job that's out to get the Russians. And so probably you could imagine a panel of 3 judges, if there were to be such a thing, in which you would have a Ukrainian or someone who has an association with Ukraine, and then 2 others, but in particular a president of that panel who is not Ukrainian. It's a really delicate balancing exercise. But in terms of the work that has to be done on evidentiary matters, which is also going to include intelligence and who has done what, one aspect that I'm particularly keen on that should be addressed, it failed at Nuremberg, but it is not a reason for excluding it, is beyond the key people at the top table, the key finances, who are the individuals who are providing the funds to make the perpetuation of this war possible and make sure that you have a number of those people on board as individuals of interest. That's going to require intelligence work from the Ukrainian intelligence services, from Western, European, British, American intelligence services. I think it's a cooperative effort, but the legitimacy of the end product is going to turn on the nature, the qualities, the nationalities of the individuals, and it must be a truly, I think, international effort. In that regard, it is very regrettable to me across the board that there's not been greater global South engagement in this war and in this conflict, and I, for one, will be particularly pleased to see a chief prosecutor, for example, who comes from the global South, or serious prosecutors and judges who come from the global South, to enhance the legitimacy of the institution.
Mr. Sands, I'm conscious it's 1:55 to 2, so you probably better get going back to court, but thank you again. Thank you so, so much for being here. Thank you. Yeah, thanks very much. And a reminder to everyone else, our second panel will start at 2 o'clock, so you've got a few minutes to make a phone call or anything else. We'll see you back here at 2. Thanks. Let's see the time, how many minutes? 3. All right, welcome everyone to panel number 3. Panel number 3 will discuss investigations and evidence, the challenges facing building and prosecution. The panel 3 will be moderated by Arif Abraham, barrister at Doughty Street Chambers and leading expert in public international law. He is joined by Mr. Andrei Kostin, Prosecutor General of Ukraine. We also have Tony Cadman, co-founder of the Guernica Group and joint head of chambers at Guernica 37 International Justice Chambers. Jason McHugh, senior partner of McHugh Jury and Partners LLP, an international public law practitioner. And Dr. Mark Ellis, chair of the International Bar Association. So I'll hand over to you, Ari.
Thank you very much, Bella. May I begin firstly by thanking Justice and Accountability for Ukraine and also FTI Consulting for bringing us together, and in particular our esteemed colleagues in this panel. They need little introduction, but needless to say, we're extremely pleased that we have them here and we can benefit from their experience. As we've already heard today, this year marks the 10-year anniversary of the invasion of Ukraine by Russia, beginning, as we know, with the illegal annexation of Crimea and the city of Sevastopol in 2014, and the unlawful occupation of parts of the Donbass. But also, as we've heard, it's a 2-year anniversary of the full-scale invasion of Ukraine in February of 2022. Now, since then, the campaign to create the Special Tribunal to hold principally the senior and political military leadership of Russia and Belarus for ongoing acts of aggression has progressed in earnest. We've heard that now some 40 states are holding regular discussions on establishing the tribunal, but there does remain, and we ought to acknowledge, some key challenges. The first is the coordination, collation, and preservation, as well as the assessment of evidence. The second is the application, as we've heard, of personal and possibly functional immunities of state officials. And finally is the fast-moving geopolitical considerations, particularly the support of global South countries, which tentatively threatens the tribunal project. Nevertheless, critically important facts on the ground have been established, such as the creation of the International Center for the Prosecution of the Crime of Aggression in Hague in July of last year, under the auspices of Eurojust, the strong support of the Council of Europe, and also the active participation of the EU to advance this initiative generally. And as such, this panel will consider what is needed to advance specifically the investigation and prosecutorial work, particularly whilst there is an impasse, as we've heard earlier from Philippe Sands, on the modalities of the tribunal among states. My suggestion is we'll have a discussion with our esteemed colleagues for about 35 minutes, and we'll use the remainder of the time for questions and answers from the panel. We'll begin with the Ukrainian Prosecutor General, Andrei, if we may. And the first question is really about this International Center for the Prosecution of the Crime of Aggression. Perhaps, Andrei, you can tell us what this precisely is, who is involved, and what work should this relatively new and unique center be doing?
Thank you. Good afternoon, everyone. The International Center for the Prosecution of the Crime of Aggression is the first, but very crucial step towards the administration of justice against the supreme international crime crime of aggression. In short, the center is a platform embedded in Eurojust that aims to support national judicial investigations into the crime of aggression committed by Russia against Ukraine. It became operational in July last year. And actually, it took us only several months when political decision was taken on the level of Eurocommission, and it was first announced to be established on 3rd of February, and it became operational on 3rd of July, which is once again about changing approaches of our partners, friends, and allies towards how decisions could be converted into real actions. This is what really Ukraine needs. The ICPA it's truly unique by its nature. It's the first judicial hub on international level since Nuremberg and Tokyo, with specific mandate to secure crucial evidence related to the crime of aggression and facilitate the process of case building at an early stage. Currently, the ICPA team is composed of Ukrainian, Lithuanian, Latvian, Estonian, Polish, and Romanian prosecutors. And we are pleased that United States also seconded Special Prosecutor to work with colleagues. In total, 16 prosecutors and 4 investigators, along with 7 participants from the International Criminal Court. So what we aim to achieve within the ICPA? The most important aspect is documenting the evidence as well as agreeing on investigative and prosecutorial strategy. We are not naive with our aspiration to establish the Special Tribunal for the crime of aggression. It will take time, it will take resources and political will of the international community. Meanwhile, we must preserve the evidence and prepare for the case. So basically, the center is a back office in action with access to various resources within Eurojust and in The Hague.
Thank you very much. Thank you. Jason, would you like to come in on this as well?
Yeah. Hello? The thing I'd like to say is I think it's really important for the International Centre to actually think about the efficiency and effectiveness of accountability across the board and what justice means in this sake. The crime of aggression is very important. Philippe just mentioned it's the Uber crime, right? It's the one that keeps peace here. It's the main issue. It's also the crime which any form of damages, reparations for Ukraine should be pegged onto. It's the easiest one for accountability in that. And accountability and justice for Ukraine means reparations. Let's face it, Putin mocked prosecution in the ICC, right? What he doesn't like is money being taken off him. Justice has to deal with both of those because they're both very important. And I think what the centre should be doing is, yes, working on this tribunal, also working on the register, which is very valid and doing a great job there, but how to bring that into the damages claim and how to make the legal claim through this tribunal on the back for the reparations claim, which then will allow confiscation through a proper judicial assessment of damages.
Great. Whilst we've still got you on the mic, what is the kind of evidence that would be needed to prove the crime of aggression, both principal and accomplice liability, and how does the crime relate to other international crimes?
The way the crime's basically structured is that you've got the act of aggression, whether that's an invasion or a bombardment, or they're listed in the act, with an earlier speaker went through it. That's actually relatively straightforward. What's harder is the second element, which is the knowledge of the manifest violation and of the planning. And I was thinking last night, what is the biggest problem that particularly our friend here is facing? And it's one of culture. And that's because when you look at the Nuremberg trials, and we saw Goering's speech, his very famous speech, he actually went through because it was his culture to say, what we did was right, this is what we were doing. There was admissions. all over the place. The Germans kept records, minute records of everything, because they believed in the process of what they believed. The Russians are quite different. The Russians culturally come from, if you look at Stalin's purges, what they were doing there in the NKVD was, they're guilty, now build the evidential case for where we want to go to. It's going to be the same problems that our friend is facing here, of how to get around that.
Andre, would you like to come in on this question as well?
First of all, small comment on the first contribution. I would not say the Tribunal for the Crime of Aggression and other elements, but reparations and reparations. Because these are all elements of our web of accountability, criminal part plus civil part. If we will have time, I will explain more in details. And of course, all these elements are interlinked, and all of them about ensuring justice to all victims and survivors of this war and to Ukraine as a state. So all of the elements are, for me, equally important. And they, once again, contribute to each other. Coming back to the evidences, of course, we respect and are bound by the rules of evidence. But I think that the gravity and scale, as well as unjustified nature of the intervention, leaves no doubts to anyone. Russia actions were a manifest violations of United Nations Charter's prohibition of the use of force. Second, we all know that the crime of aggression is a leadership crime, encompassing both political and military elite, so-called masterminds of Kremlin regime. The criminal elite has been involved in various stages of the crime: planning, preparation, initiation, and execution. Third, we all understand that it will be difficult to get hands on the most of valuable evidence from the very beginning, such as the records of official meetings where the act of aggression was discussed or content of official documents, though it's not totally impossible. Then there are public, oral or written statements, often televised by Russian media. One could even say that Putin gave an open and honest testimony in front of the whole world on 24th of February 2022. Third, it is operational plans, strategies, tactics, arranging movements of troops, issuing of orders and instructions in relation to military leaders. In our cases, the crime of aggression preceded all other international crimes, as well as continues to shell atrocities as Russia carries on bombardments of whole Ukraine, along with the occupation and annexation of parts of Ukrainian territories.
Thank you very much, Andre. Toby, you have a particular specialism in prosecuting international crimes. Could you tell us what are the kind of challenges prosecutors will face working at a future tribunal?
Thank you. Before I answer, just two comments I'd like to make. First of all, can I just say it's an absolute pleasure to be on a panel with Prosecutor Costin, who has quite possibly one of the most demanding and difficult tasks. So first of all, I'm grateful for that opportunity. And second, no matter how negative I'm about to get, I just want to say that this is a process that I fully support as one that is absolutely essential, as we've heard earlier, not just for Ukraine, but for the whole of humanity. I think it is an incredibly important process. It is a very difficult process, and we can talk about the challenges. But looking at it from a prosecutorial perspective, and we've heard even this morning in some of the other panels, some of the real challenges, such as legitimacy. With a process such as this, legitimacy of the process is always one of the greatest challenges, which was why, in particular, I asked Philippe the question as to how he sees the role of Ukrainians in the process. And I think we can understand that the level of involvement from Ukrainian prosecutor judges and lawyers will impact upon its perceived legitimacy, both in terms of whether it is perceived as being independent, whether it is perceived as pursuing a just result. So I think that's one of the first things that has to be considered is where are judges and prosecutors going to sit in this process? I was slightly critical earlier when I mentioned the Kosovo Specialist Chambers, because I think the theory behind the Specialist Chambers is a very important thing for Ukrainians to consider in any initiative, but to exclude Ukrainians, as we have seen with the Kosovo example, does not contribute anything to Ukraine. And I think that's one of the things that we have to think very carefully of. The other issue, of course, which is why one of the reasons why we're talking about an international process is enforcement. One of the greatest challenges, certainly during my time in Bosnia, where we were a successor institution to the Yugoslav Tribunal, was as a national institution, you had no enforcement mechanism outside of your borders. So how do you get individuals before the court? How do you enforce judicial orders outside of your own borders? Which is why it has to have an international mandate. But I think one of the greatest challenges that we're going to see is setting reasonable expectations as to what the process can achieve. And a lot of that boils down to having a workable prosecutorial strategy. Now, Prosecutor Costin had mentioned that in his own remarks, in terms of the collection, the collation, the analysis of the evidence, but also what is the prosecutorial strategy? How do you determine what cases you're going to prosecute? That is the single most difficult challenge that I've experienced in every national and international prosecutorial authority I've ever worked for or ever been involved with, is how do you select the cases that have the greatest impact? Now, in the crime of aggression, it is a slightly easier task because you are going at the very, very top. But nonetheless, you have to ensure that there is a workable, transparent, and publicly defendable prosecutorial strategy. And I think that will be the challenge for any prosecutor who is appointed.
Thanks, Toby. Andre has already given us an indication of the kind of evidence that will be necessary. How would you say that investigators can be supported to uncover that evidence to support a future tribunal? And what would you say needs to be done right now to help establish the elements of the crime against, as you have already said, the appropriate perpetrators?
So we've already heard a little bit, both from Prosecutor Costin and from Jason, as to the process that has already started in The Hague. I think the first point is it needs to start now. There needs to be a legal framework. There needs to be procedures set in place as to how that evidence is going to be collected, how that evidence is going to be analyzed. So just to give an example, a comparative example of how we first started in 2002, 2003 in Bosnia, where we had literally hundreds of thousands of pages of material to review. And I say material because at that stage it's not evidence. You've got to have a process in place that, first of all, can review that evidence, that can analyze that material to put it in the form of a workable case theory, because you're going to be having material coming from a variety of different sources. You're going to have the public statements by military and political leaders. You're going to have intelligence that has been gathered on the ground. You're going to have witness accounts. Because you have such a collection of different types of material, it is a very long, laborious and somewhat painful process of reviewing all of that. So what I would say, and to draw another analogy, when the Kosovo Specialist Chambers first started, it started with an investigative commission, an investigative body. And I think that is the right way to start. That needs to be set up, that needs to be formalized. There needs to be effective procedures and protocols for how material is going to be analyzed. And as we've already heard, I think there are 16 prosecutors there now. This is a process which is going to be ongoing, but I think what we have to see is there needs to be much greater coordination from the various different war crimes units around Europe, and I know that there is this process to a certain extent. But the one thing that we are very good at in these internationalized process is doing things very badly and not learning from our mistakes and not coordinating. So I think the one message that we have to ensure is that the process has to be properly coordinated with investigative agencies providing direct support to this body which is set up in The Hague.
Thank you. Yeah? I think what's very positive, what I hear, very positive from your comments, it's very important that practically we are doing all of this. And starting from our national investigations, and why the International Center for the Prosecution of the Crime of Aggression, why it is like a part of joint investigation team. Because the member states of joint investigation team, you know that namely Ukraine, Lithuania, Poland, Latvia, Estonia, Slovakia and Romania, most of them has crime of aggression in their penal codes. And they have opened investigation. And they are collecting evidences all the time, not only for which they have some access through their investigative authorities or through intelligence sources, but also through witness statement, because it's also important, because you know that tens of thousands of Ukrainians who are refugees in Europe, they have a right and possibility to give their evidence statements, not only oral, but also video, photo, and many others. And this work, you told about coordination, this is one of the most important things which we are doing, starting from the autumn of 2022. And for that, Eurojust is absolutely helpful. And even the instruments we have created to coordinate work, not only of JIT member states for the crime of aggression, for the other war crimes, but also 20 countries who opened their national investigations. And you know that we have had first coordination meeting, though all of them are investigating independently. So we can't interfere, but in order to understanding that we have the same goal, we have the same aim, and we need to coordinate our efforts in order not to lose, but to win. We have first meeting in The Hague on 1st of December 2022, which was not publicized. We don't disclose what we discussed. We disclose on just fact of the meeting. And the instrument, which was created by Eurojust, and we all support it, is so-called CSED. Maybe some of you don't know what is it. CSED is Core International Crimes Evidence Database. Now it's fully operational, where all countries who opened national investigations can include or input information about the evidence. And this information is very detailed, so that the others who can have access, the other countries, can say, oh, look, I have the same case. And part of evidence are already given in Poland by our refugees, and we have something in Ukraine or in Slovakia. And this gives us an opportunity not to lose these evidences, because before, what happened in many cases, people, Ukrainians, go, report, give evidences, and they were procedurally documented, but keep in file. So this is very important. I maybe now I'm telling a little bit more or wider about than the only crime of aggression and investigation, prosecution of it. But this is important because we use the same approach for every war crime and crime of aggression, including the crime of aggression. So
for prosecutorial strategy. Thank you for mentioning this, and thank you for mentioning this in my remarks, because this is the most important task of the group of prosecutors who are doing their job, with the help of their national prosecutorial offices and their national investigative authorities. And of course, work done by all of us is we are not waiting when legal solution on the modality of tribunal will be settled and the tribunal will be established. This is critically important that the ICPA is now preparing the framework, preparing the basis for the future prosecutor of this tribunal. And I hope that this work will make not only easier the work of the prosecutor of the tribunal and the tribunal itself, but I think that we will save a lot of time, because time is of the essence in our situation. Even mentioning first arrest warrant of the ICC, I told this many times publicly, 5 months of work. 5 months of work, because we prioritize this only case. We stopped all others, prioritize this case, 5 months. For the ICC is incredible. It's changing of culture, because we, and this is the position of my very esteemed colleague Karim Khan, it's about delivering justice in time. Delivering justice to victims and survivors while they are still traumatized, but still alive.
Thank you, Andre. That's really valuable. Mark, you've been a senior legal advisor in several international courts and tribunals. Would you like to make some remarks before I ask you a specific and difficult question on what you've heard so far?
No, it's so critical that the prosecutor is here, because setting out this strategy, and particularly with the support of the evidence gathering, that is critical here. And perhaps later I'll say back to what Jason had said about a little bit an issue of Nuremberg and the experience there with the experience today. One thing that is dramatically different in the sense of what the prosecutor said and what Toby said, what Jason was talking about documentation as being so critical during the Nuremberg trials, witness statements, orders of annexation, all of these are pretty relevant to what has happened in Ukraine. But there is a kind of a dramatic increase that is different here. The ICPA is one of the real unique aspects now of focusing on building up the evidentiary base. But I went back to a law review article that I wrote years ago about surveillance. And the surveillance policies in states is quite extraordinary, whether it's the Five Eyes, whether it's the National Security Agency. There's a litany of these coalitions and this collaboration gathering evidence in ways that it was almost unimaginable even 10 years ago for me, and right now it must be accelerated by 2 or 3 times. So I'm fairly confident that the evidence gathering to build this case is straightforward, and I think it's there, and I think we'll see it there. So I just wanted to touch on those points.
Thank you, Mark. A common, I guess, a common difficulty that's been raised in all of the discussions so far is this idea of personal immunities as a hindrance to the establishment of the tribunal. In addition, you have, of course, the issue of functional immunities when it comes to prosecution of alleged perpetrators in foreign domestic courts. And we've just heard from Andre that justice delayed is justice denied. How would we one day secure the arrests of senior Russian or Belarusian leaders at a future tribunal?
Well, I think we have to be realistic about this in the sense of arresting, apprehending those most responsible. And of course, I always focus on Vladimir Putin. And I think we just have to recognize that this is a long-term game, but that's what international justice is about as well. Those two principles, personal immunity, functional immunity, they're embedded in customary international law. They're critical. The discussions this morning dealt with both this bifurcation, political issues and legal issues. The legal issues, to me, fall into this area. It's the most critical point here in creating a tribunal, special tribunal. Can you get over the legal hurdles? And the legal hurdles, for me, would be the personal immunity and functional immunity. We know that the arrest warrant case, as was discussed earlier, sets forth limitations on being able to create an exception, certainly to personal immunity, but it gives you a way out, and that is an international court or tribunal, something that is recognized in the same way that the court, that the ICJ recognized other existing tribunals. But of course, there's a big difference. And the tribunals that have come before us are either Security Council created tribunals or the ICC. Of course, in here, the gold standard would be a UN Security Council created tribunal. We know that's not going to happen. A UN General Assembly resolution, we know the complexities of that, the political elements of that. So then I tend to fall into, well, can we move into a internationalized court? That too has been discussed. And to do so, to get over these immunity hurdles. And so it was discussed this morning. It was a fascinating discussion, I thought, particularly some of the interventions from the audience. Well, who makes that judgment on whether or not this special tribunal that we desperately need to create, who makes that judgment that it's internationalized enough to get over these hurdles? Some were talking about the numbers. Is it 40 countries? Is it 80? Is it 120? We know the ICC has, what, 123 parties? Is that the baseline? And my response to that is, I'm not sure we know. This is new for us. We have models, but I don't think any of those models fit exactly into what we're about to do. And so therefore, the question is, well, who makes that judgment? For me, history will make that judgment. And until history makes that judgment, we should move forward and create the best modality, the best model that we can, understanding that there are challenges and limitations and hurdles, but we cannot wait to decide we have a perfect structure, because I don't think we'll get a perfect structure. We just move that forward. And then the last point on functional immunity as well, that's critical. It was discussed earlier in the panel about the EU's position and the increasing number of states that simply do not recognize the exemption of functional immunity for international crimes. That is absolutely the right direction the world needs to follow. But we still have limitations there because of the arrest warrant case I've already mentioned, but most importantly, the International Law Commission and its 2019 draft article that goes very far ahead in saying we can no longer accept these types of functional exemptions. And yet, they don't add the crime of aggression. I find that illogical, but that's where some of the politics comes into play. So it was interesting that Philippe was talking about how will these immunity issues be dealt with in a internationalized tribunal. I'm a bit more optimistic than he is. I think it will go forward, and I think there'll be an exemption to both the personal immunity and functional immunity. Why? Because if there's not, I don't understand why we would go forward with the tribunal. So that would be my view.
Thank you, Mark. Andre, a related question for you. What are the real prospects that a perpetrator would be apprehended? And should we, as some have suggested, be contemplating trials in absentia, given the problems of having a fair trial, and also given the adverse experiences with a recent tribunal, the Special Tribunal on Lebanon?
First of all, this is a very frequent question. How can you ensure Putin and or others to appear behind the bar of tribunal? It's not a question for us, actually. Our job is to prepare the case, to collect evidences, to collect enough evidences to charge, and in case, for instance, Putin will appear at the ICC, we know that the ICC cannot try in absentia, then ICC will be ready. So we will not wait, we will do our job, do as fast as possible in line with the standards of evidence collection. The same could be applied to a special tribunal for the crime of aggression, but there we have more freedom because it's international law. And of course, the best possible option is to include the provision that allows to prosecute and to try in absentia. And I can give a lot of arguments for that. But of course, Mark, you also mentioned the discussion which was today about the political and legal. We will always be within political and legal discussion about tribunal for the international crime committed, because it's a combination of legal structure supported by political will. And different legal structures could be supported by political will depending on the political situation and depending on politicians, whether they are brave enough to take risks, because what we are doing, Mark, you're absolutely right, is something new, based on previous experience, but new in its nature. So, why in absentia? Not only in order to ensure that this tribunal will have full possibility to get to the verdict and not be dependent on if Russia will build, you know, like Russian walls on their border, not allowing anyone to get out. The other very important reason is more political, once again about combination. More political than legal, but for me, not less important, because now the group of potential adversary states are looking very carefully at us, at the civilization for which values of freedom, democracy, and justice are not just words. Looking very attentively, because if they see that we are weak, you will all see repetition of such aggressive actions and wars in many other parts of the world, unfortunately. And this will cost all of us much more than creation of proper tribunal at the moment as an element of our fight for justice. Because winning or getting the victory in our fight for justice is not less important than victory on the battlefield for our territory and land. Not less important, because there could be no peace without justice. So, these are two main reasons. I would add third one, probably, which is important for Ukrainians, because every Ukrainian knows, and this is actually one of the elements which is different from the Tribunal for Lebanon.
because this tribunal is only concentrated on the crime of aggression, and the list of potential perpetrators is well known. And all of them definitely will know about the establishment and the work of this tribunal. It's not about situation that they can enjoy the right saying, look, we don't know, we've been not informed. And of course, it should be the guarantees to retrial in like appeal chamber of this tribunal should be guaranteed for everyone who will be prosecuted, if tribunal will have right to try in absentia. So, one more argument, if you allow. What is important for Ukrainians? Not only to ensure full accountability, but also to ensure the justice for Ukrainian servicemen who were killed in course of this aggressive war. Because the crime of aggression is practically the only international crime which is committed against Ukrainian servicemen. And this war of aggression is not the war between Russia and Ukraine. Like Russia and Ukraine are trying to fight each other for the territory of some third country. This is Russia who is aggressor, and Ukraine which is the victim of this aggression. And to prosecute and to punish those who started and waged this aggressive war means to deliver justice to Ukrainian servicemen, Ukrainian heroes. And let's not forget, not all of them are and were professional servicemen, because professional servicemen take a risk to be killed even in peaceful time, while the major part of our servicemen are yesterday were civilians, and they are to protect our land. And this tribunal is also to deliver justice for them.
Thank you, Andre. Toby, do you want to come in?
I hate to disagree now after you've received a fully merited round of applause for what you've said, but my concern with trials in absentia, and I think the Special Tribunal for Lebanon is a classic example of that, is it becomes a hugely costly, and I hate to say it, academic exercise. When we look at the cost of the Special Tribunal for Lebanon, which cost more than $1 billion to deliver verdicts in which no accused were ever presented before the court, the only individuals who were prosecuted were in relation to contempt cases. And when you are working with limited resources generally, the fear is that by having a process of trials in absentia, it does become little more than an academic exercise. I don't think you can compare the two situations, Ukraine and Lebanon. They are two very, very different situations. But I think that generally the notion that you proceed with trials in absentia in anything other than a last resort, I think is problematic.
Jason?
Can I just come in with an opposing view, if you like? I spent years bringing cases against terrorist groups. One of the things is they never turn up. They have a choice to turn up. They don't turn up. Why don't they turn up? They don't turn up because they don't agree with the rule of law in our courts. It's the same with Russia. I'm sorry, we go through the case, we professionally do it. We allow them to have lawyers who turn up and act and argue their defense. If they don't choose to turn up, that's their problem. And I think in these cases, I think we've got to get beyond these issues and really support it. I don't have a problem with abstention.
Mark?
Yeah, sometimes it's surprising to listen to yourself answer a question when your life has been on the opposite side of this. And the opposite side of this for me has generally been leaning into the defense. Why? Because, as the prosecutor knows, I'm a big believer in ensuring that you have fair trials meeting international standards of impartiality, because if not, it's pretty much a waste of time. But on this one, I have been leaning more into trials in absentia for Mr. Putin. And I base it on the fact that there are restrictions, pretty dramatic restrictions. The ICC don't allow it, doesn't allow it. The ad hoc tribunals don't allow these trials in absentia. But generally, you can find exceptions. Legally, you can find some exceptions. Jason, I think, was the most relevant one. You have an accused that, first and foremost, is aware, has knowledge that the arrest warrant is out, but has absolutely no interest and will not show up. And that could be for a long time. And therefore, it leans back into this issue of Ukraine and the Ukrainian people needing to have some process of being able to set forth this crime. And assuming you have the protections that Jason had said, and I'm sure Toby would agree, for the accused, even when the accused is not there, there are structures you have to follow, then I think I'm more open to this for this particular position.
Thank you, Mark. We've got about 17 minutes left, and I've still got 2 questions for the panel. So maybe I'll wrap the questions up together, and perhaps we can take a view from each of you, and then we'll open the floor for questions. Now, much of the investigation and possible prosecution, as we've heard, will depend on the structure of the tribunal, and a lot of that will be set out in the statute and the rules of procedure and evidence. Firstly, what do you think it is essential to see to ensure the tribunal is an actual workable model? And also, what would you like to see from politicians and policymakers that will be listening today? Perhaps I'll begin with Jason, and we'll move along the panel.
Just generally on the last point, one of the things, and again it's come from a practical thing, we're bringing a case for some Ukrainian victims against Wagner Group. And we've had material evidence from yourselves. It's brilliant. From your defense services, brilliant. From British, American governments, brilliant. But there's been a standout. And the standout has been civil society. The amount of material and evidence they've been able to throw in. And I say this is important because Nuremberg didn't have it. It's a big advantage we've got. And someone here earlier was from Open Society. Open Society has a meeting every few weeks with 54 agencies on it, NGOs, who are all involved in evidence gathering. And it's these chaotic meetings, but they're churning it. And it's a big advantage. So I'd like to see that being worked into the model, because it's also important on the depoliticization of it, that it's coming from organizations like that.
Thank you. Toby?
I would agree. I made the comment earlier that I think that there has to be engagement with Ukrainian professionals, but it has to be something which fully embraces and incorporates civil society, because again, as Jason has said, that is how you depoliticize, and that is how you ensure that the process is perceived as being legitimate.
Mark, and perhaps you might also add any lessons we might learn from Nuremberg, Tokyo, and...
Oh, that's right. This is much more important, I think, because this is really, first of all, what Jason said about civil society. If I were to make one recommendation to the core group, it would to open up the dialogue with civil society, actually, because I think we can be very... civil society can play a very important role in promoting what the core group is trying to accomplish. I understand the complexity and political issues there, but I would like to see this because I think this would be helpful. If I had one message to the politicians, which some of you know, this morning I had an op-ed in the London Times, and I talked about this is it. This war is not complex, but the consequences of us not supporting Ukraine and not ensuring Ukraine in the end is victorious, the consequences are massive. And if we're saying as an international community that this is not the right time to ensure that those at the very top who have initiated this most egregious violation of international law are not brought to justice, then that's it. Then there's nothing more to do, and it will go into, I think it was mentioned earlier, go into just the history books. This is the time to act, and we need to do that.
I didn't actually give my message to the politicians, and I don't want to lose that opportunity. Just following on from what we've just heard from Mark, I would say, if nothing else, if we do nothing else, and we've had this discussion frequently, if we don't do the right thing now, think not of what this conflict is now, think of what the next conflict will become. And I think that is the important thing. If we do not take appropriate action now, international criminal justice, as we understand it, will be dead. And so I think that is why we have to take action.
Andre?
First of all, colleagues, thank you for mentioning the unique role of civil society, the NGOs. We have the platform within my office, it's called International Council of Experts, with more than 40 NGOs who are collaborating with us, and they even decided the directions of activity where they have experience and where they're concentrated on, and we add more and more directions while some of the NGOs are ready to extend their activity or the others join. The last elements we added last autumn were the crimes against environment, the project which I started literally in October 2022. We started to invest in it, understanding that no one before Ukraine, no one in history prosecuted crimes against environment as war crimes. And we added more avenues like cyber attacks as war crimes. We will open now additional element, crimes against cultural heritage, not only destruction or intentional destruction or damage as part of cultural genocide, which is also construction which exists but not very well developed, but also illicit trading, which was not also prosecuted before in course of war. And for each of that directions, for one of the most complicated problem, I'm now talking about civilian detainees or civilian hostages. Not only children are kidnapped, but grown-ups also are kidnapped and illegally detained in Russia. And there's a lack of not only of the law, there is a law, so the deportation or forced deportation is war crime, but there are no instruments how to return them back home to their children. In first case, parents are waiting for their children. In the second case, children are waiting for their parents. And if you combine this situation with the manipulative starting of or opening of criminal cases against Ukrainian civilians in Russia, for instance, for criticizing of special military operation which is criminalized in Russia, or using the word war, we all understand this is crazy. And it's a situation when these people were forcibly taken to Russian territory and then they started criminal cases against them. So it's a very difficult story. And case of deportation of children and civilians on so massive scale, once again, it's first time in Europe after Second World War. Even in conflicts on territory of former Yugoslavia, it was not the case. There were all other war crimes committed there, very brutal, but not this case. So civil societies are always with us, and we are collaborating with them. And this is a great idea, a little bit to open the door of core group meetings, because it's not now something which is a top secret. And maybe engaging more lawyers, with full respect to lawyers in MFAs. I think that
adding more lawyers, maybe from ministries of justice of the countries, or, I mean, respected academicians will contribute. And for politicians, I think, once again, I told this several times, politicians, let's say like this. If we all understand that war of Russia against Ukraine is war of civilization, it's civilizational war, and if you as partners and allies and friends of Ukraine are standing with us, then of course, in order to win jointly this war, we all need to be brave. It is impossible to win the war, and I mean, I'm not only mentioning war for, I mean, victory on our battlefield. I always include victory in our fight for justice. In order to win this fight, we all need to be brave. It's impossible to win the fight without bravery in time of war. So my message to all of our politicians, I mean, politicians of our partners and friends, be brave like Ukrainians. Be brave like our president. Take decisions which could be risky, because it's impossible to be brave without taking risk. Don't think about your short-term political cycle or political career, because we are fighting for values which are the basis of all societies here in Europe and beyond. So this is fight about this. And to be brave means to be brave. Means not only to say brave words, but to take brave actions. This is my message. And this is not only my message. I think it's a message of every Ukrainian. And it's not about critics. It's about you to feel what we feel. That's it.
Thank you very much. We've probably only got about 10 minutes for questions, and we have a very knowledgeable panel, and we're extremely privileged to also have the Prosecutor General with us. So it'd be great to have 3 or 4 questions if we can. When asking a question, please give your name and affiliation as well. Tanya?
Thank you so much, guys. It's been brilliant. Appreciate it. My name is Tanya Mulyasau. I'm Director at Justice and Accountability for Ukraine. We are brave, and we are here to advocate for the cause, to support Ukraine in its battle for justice, of course. I'm going to quote Frank Hofmeister, actually, today, who mentioned earlier, if we would go to the General Assembly right now and ask the countries, you know, do you agree that this is crime of aggression? 140 countries would say yes, and another 100 countries would say collect evidence. So my question is, how much is enough evidence for those countries to actually say yes, it is the crime of aggression, where we could go and do further work and, you know, ask them to join the battle for justice against crime of aggression? Thank you.
Mark, do you want to take that?
I don't. Getting back to what has been a common issue today, I think, is the political part of it and the legal part of it. The legal part is not the issue for me. It's not an issue of the evidence is there, as we've described, particularly with the UN General Assembly. That's all political, and this is that political willingness that is needed to move any of this forward. But I think I have no doubt, no question that the evidentiary base, both internally within Ukraine and the prosecutor and with the ICPA and lots of other mechanisms, is solid. But regardless of what that evidence is, if the political willingness is not there, that's the challenge. That's what we have to get over with. And I think it gets back to what Toby said, what Jason, all of us are saying, that the issue here is the survival of what I think is post-World War II legal order. If you want to see that continue as the base of how we operate, then this war needs to be won, and those that violated these principles of international law need to be brought to justice.
I guess what I'm looking for, define 3 steps, just simplistic steps. Here's the evidence, it's collected. What do we do when we go to those countries? Is there a uniform process? What's the evidence that is enough? Just, thank you.
I mean, I think it's not that way round, is the simplest way of answering that. The question is, give us a court, let us put the evidence, and let the court decide to prove the case. So going at the moment, you're going on exactly what our friends are saying here. This is about rule of law stuff. There could not be a graver example of what the Russians have done to destroy what we've built since 1945. If we care in it, and any country cares in it, this is the moment now. Provide that court, let them then prove the evidence.
May I add one more argument? I fully agree that this is completely political discussion, because the evidences of the act of aggression are like visible, they are public. Everyone knows that in our situation, ICC has no jurisdiction because of legal reasons. But you can use it as an argument for the countries who are full members of the Rome Statute. And if they ask for the evidences, to add to what was mentioned, give us a court, you can say, okay, but if ICC would prosecute this case, you will also ask, give us evidences for us to think that it's potentially act of aggression was committed. So they will say nothing. They will have no arguments. If just ICC have the jurisdiction over this case. So I fully agree, it's just political. Those who don't want to take decision, they try to find reasons. Yeah.
We've got just about time for 2 more questions.
Hi, I'm Ollie Troan. I'm from Mercurian Partners, which is actually Jason's firm, but this won't be a softball question for him. I wanted to bring us back to the in absentia point. Tom, I appreciate you're representing, or a minority on the panel, about the trials in absentia not being able to go ahead. I think I wanted to just ask sort of 2 points on that. First, given the chance of getting Putin, Lavrov, et al. In The Hague, whether that chance is obviously very, very low. So in effect, does that not mean that your position is actually then anti the establishment of a special tribunal? Because in effect, you're saying without that, we should never have a special tribunal, and therefore a tribunal basically can't be established. And secondly, if there was a damages assessment added onto it, given a number of assets, or there are, several $1 billion worth of assets in the EU that we know are not in absentia, they're here, would that move the dial?
You want Toby to, I have some thoughts on that, but Toby, why don't you answer and I'll say.
So first of all, I think as we've all said, looking at this with a level of realism, we're not likely to get Putin before a court anytime soon. When I expressed the view that I'm not in favor of trials in absentia, I'm not in favor of it because it becomes very costly, and if you ever get those individuals, if they're arrested, then you have to go through the process again, and it doesn't necessarily offer victims a just resolution. I recognize that in a situation such as this, there is very little prospect of getting those that you want to prosecute before a court. And so you have to look at that and think a trial in absentia is probably the only way that you're actually going to be able to process this. But I think that there are risks associated with that have to be very, very carefully considered. And of course, as we've spoken about the reparation, the compensation schemes, that is a process that can feed from those trials. It has to be, in my view, the last resort. You have to do whatever you can to get those individuals before that court. But recognizing that right now, the likelihood of getting Putin or any other senior Russian official before that court is quite unlikely. But that doesn't mean that it's going to remain like that forever. And what we may see are trials going forward in absentia of senior officials. We have to all hope that Russia will eventually return and that there will be some level of democracy and adherence to the rule of law. We have to hope that. And then that is the time when many of these individuals will effectively and hopefully be brought to justice, as we've seen with other world leaders. I mean, that level of immunity and impunity does not last forever. And I think a lot of the focus can be at this stage on ensuring that the evidence is there, ensuring that these cases are ready to go once you are able to actually get those individuals and bring them before the court. I think bringing them before the court is the ideal, but it may mean that in the short term, we have to focus on something which is less than ideal.
Just 1 second on that, because I wanted to add what Toby said. It is, we have to look at this in the long run. It's a long game. So in the short time, no, I agree with Toby, it's not going to happen. But this is what's so extraordinary about history. History shows us that environments change. People's support for a leader changes. I worked and lived in the former Yugoslavia before and during and after the war. If you would have asked me during that time when the atrocities were happening that we'd have an international court focusing on this, I'd say that's doubtful. If you would have told me that Milosevic would lose his way in this country I was living in, I would say that was impossible. I've completely changed my opinion on this because we see, whether it's al-Bashir, Charles Taylor, things change. And as odd as it might seem now to think that Putin that one would lose favor, that he would lose favor with his people, it's not impossible, and we have to keep our attention on that.
Thank you, Mark. Before thanking our incredible panelists, we'll give just a minute to Andre to make some final remarks. Thank you.
Thank you, Mark. You mentioned your story, and I always quote you and some other colleagues who started as lawyers for tribunals for Yugoslavia, and who told me completely the same story, that they never believed when they started that Milosevic will appear. This is about my answer. So we need to do our job. God knows what will happen. We need to be prepared for every case. I will just mention one date, 10th of October 2022. Who from those who are from Ukraine, who remember what was this day about? Yes, first massive missile attack on critical civil infrastructure. It was damaged before, but first massive attack was on 10th of October 2022. Why did I mention this date? Because few days after, first governments officially supported the necessity to establish Special Tribunal for the crime of aggression. Our discussions with the governments, with the MFAs, with countries, with our friends and allies started in March, April 2022. With help of our real friends who really tried to push this story inside the Western countries. But the first official message was after first massive missile attacks. What does it mean? And core group was established and countries start to join, and not only from Europe and from Americas, but the others. What does it mean? It means that all this about political will. Lawyers will do their job. We have wide framework of international law. We have existing experience which could not copy-pasted for Ukrainian case, but which can be used, not only positive, but also negative experience in order to avoid commission of the same mistakes. So this story on Special Tribunal is about political will, courage, bravery, and unity. And once again, it could not be established without lawyers. But I believe that lawyers are most committed to establish it in a proper and efficient way, because lawyers better understand than others the risks of impunity for the aggression committed against Ukraine. Thank you.
Thank you. Thank you very much to Prosecutor General Costin for what was a very inspiring call to action. And thank you for the rest of our panelists here. That was a fascinating debate and a very complex subject. We'll be back here again at 3:30 sharp to start panel 4. So please do go ahead and have a little break, and we'll see you back here shortly. Thank you. All right, welcome back, everyone. I'm now pleased to introduce the fourth panel, which will look at the impact of war and the issues facing a tribunal for Ukraine. We're delighted to welcome back Professor Dapo Akande, who will be joined by Alicia Kearns MP, Shona Jolie Casey, barrister at Cloisters Chambers and leading expert in public international law, Svetlana Morinets, award-winning Ukrainian journalist at The Spectator, and Ms. Kirsty Brimlow KC, barrister at Doughty Street Chambers and leading expert in public international law. I'll hand over to you now, Professor Akande. Thank you.
Just peered through that door because I see her go through there every time and I wonder what is there. Steps. And then she reappears there. Okay, so welcome to the last panel of the day. I know we have still the Attorney General after this. I was remarking to my panelists that the previous panel, the one just before this, was a panel that was composed only of men, and we have a panel that's composed of women apart from me. Throughout the day, we've been talking about the Special Tribunal, and of course, we're talking about the Special Tribunal for the crime of aggression against Ukraine. But of course, the crime of aggression is but one crime that has been committed and is being committed in Ukraine. There is a broader landscape of international crimes that is occurring in Ukraine, and a broader landscape of tribunals, mechanisms, and processes for investigating and seeking justice with respect to those other crimes as well. We have the investigations that the International Criminal Court is conducting on war crimes and crimes against humanity. We have Ukrainian domestic courts also looking into international crimes. And we have the domestic courts of other states as well, exercising either universal jurisdiction or other forms of jurisdiction, investigating these other crimes. So we thought that for this last panel, we will try and broaden out actually the discussion with regard to accountability for crimes being international crimes that is being committed in Ukraine. And we have a fantastic panel to do that. And what we're going to do with this panel is we're going to start with Svetlana Morinets, who's a journalist, as has just been described, works as The Spectator. She's covering the war in Ukraine, and she is going to give us a sense of that broader picture in regard to what's going on in Ukraine, and particularly with regard to international crimes. And then after that, we will turn to Kirsty Brimlow KC, barrister here in London with a practice in international human rights law, criminal law. She's been chair of the Bar Human Rights Committee, and she will draw some comparisons between, or maybe some lessons that might be learned from what's happening elsewhere with regard to what's going on in Ukraine. And then we have Shona Jolie KC, also a barrister working on international human rights law, public international law, also, I think, has been chair of the Bar Human Rights Committee, who will speak on a range of issues, including issues regarding gender equality, both with regard to what's going on in Ukraine, but also these tribunals. And then we will round off with Alicia Kearns, MP, who is the chair of the Foreign Affairs Committee of the House of Commons, significant experience in international affairs, worked at the Foreign Office, and is involved in various initiatives in this space. So I will hand over to Svetlana, and we'll take it from there.
Hello, everyone. Thank you for having me today. When we talk about justice and the peace, when Western media, analytics, leaders, when they talk about the end of the war of Ukraine, they usually talk about the peace, but the word justice is very rarely mentioned. So there is a question, will hundreds of thousands of Ukrainians who have suffered Russian atrocities, will they have peace if they don't have justice? Because peace is not just about the end of shooting, the end of missiles flying over your head. It's also knowing that aggressor paid for the suffering he caused you. When I go to the front line and I do some reporting there and I talk to people who live there and whose houses were destroyed, whose loved ones were killed or deported or tortured or raped, and I ask them what will be justice for them. And of course, they want everyone bearing responsibility for starting from the Russian soldiers who broke into their house and finishing with the Russian leadership and Russia as a state as a whole paying for their war crimes. But there are also some urgent needs because people there, they need a roof over their head, they need food to eat, they need to work somewhere. That's why I think an important part of bringing justice is making Russia pay for their war crimes and paying reparations for Ukrainians. And it's the only thing that can bring them the feeling that there is justice. Because, of course, we can think about the prosecution of Vladimir Putin and Russian commanders and Russian soldiers, but it will happen when in some years, or maybe will happen never, because Putin is not going to come to trial so easily. But what we can do is that ensure that Ukrainians who suffered from Russian aggression, that their houses are rebuilt, that the towns, the cities are rebuilt, the schools are built, the hospitals, all of that, they were bombed by a Russian army. And I think it's important to focus on that issue. And because when I talk to Ukrainians who live near the front line, they don't think about going to the prosecutor office and giving the evidence or flying somewhere to a trial. They don't have money, they don't have funds for that. They just want to keep living and trying to heal from the war. And unfortunately, it seems that for now, Russia is getting away with all the crimes that they made. And I don't know if you heard, but yesterday, judges of the International Court of Justice in Hague dismissed several crucial aspects of Ukraine's case against Russia about Ukraine wanted Russia to pay reparation for their aggression since 2014 in Donbass, especially for supplying weapons to the terrorist organizations there. But the court dismissed that, and Russia won't be paying reparations. So it's a very difficult question, and have to actually manage those processes and to use Russian money, for example, from freeze Russian assets, because if you negotiate with the Russian government, I'm not sure they will have the money or give them. They will be willing to give the money to Ukraine. But as we have a lot of frozen Russian assets abroad, we could use them. So I think right now the goal must be to ensure that every Ukrainian, no matter what their social status is or from what crime they suffered, that they receive the justice and they receive how do you say that in English? That no money can ever heal that suffering that they endured, but at least they can help them to go through this life and to build a happy life in Ukraine. That's what I wanted to say. Thank you.
Thank you, Svetlana, for setting that context for us. And now we're going to go to two legal experts. First, Kirsty Vermeulen.
Thank you very much. It was interesting listening, Svetlana, to what you've said and the focus on justice, because whenever a tribunal is set up, we hear this word. And practically, what justice is means something different to different people. On the international stage as well, there's probably an unwanted party, which is politics. And so when you're looking at a justice system within a national jurisdiction, such as in the UK, and I could say I've just dashed here from a trial I'm defending it at the moment, in a murder trial. Now, it's very different, that sort of justice, to a justice on an international plane, because you do have the spectre of politics. Now, politics isn't always something that is negative, and I'm sure it will be argued that it can be a very positive thing. But where does politics come into play on the international plane when you're looking at a justice mechanism? Well, it can actually come into play in terms of diplomacy, and also in terms of extending from diplomacy into conflict resolution. I'm going to give some examples, really just picking a few places around the world where I, in particular, have worked, so I can give my own experience and a few thoughts, perhaps, to trigger some questions later on. What do you want with your tribunal? Well, you'll want, won't you, international support, and you'll want legitimacy of the tribunal itself. What do you want within the tribunal? Well, there needs to be legal certainty for those who are accused, as well as a full guarantee of victims' rights. And as Svetlana has just referred to, tribunals are expensive. They need money. They need resources, financial resources, but also they need people resources. And that includes investigators, lawyers, evidence gatherers, because without the evidence, the tribunal will fail. And there's many examples of calls for tribunals around the world coming out of different conflicts, which have not got off the ground at all. Where's another challenge with a tribunal? A challenge is when hostilities are ongoing. And it used to be that there was much more of a lean towards setting up your justice mechanism once the conflict had ended. But there's many examples now of mechanisms being set up when hostilities still continue, for the simple reason that it takes too long if you wait for the conflict to entirely finish. Colombia's one example where that conflict was 52 years old, and it eventually went to set up a justice mechanism called the HEP, which is a special jurisdiction for peace. And that was only set up after the peace accord was signed in 2016. But it was also set up when conflict was still continuing. And there have been calls for it to be set up much earlier. Some lessons have been gained from that. What else do you need? Well, evidence gathering, particularly in relation to Ukraine, when many witnesses are children. The evidence gatherers should not be frightened of getting evidence from children. It is something that lawyers, investigators are trained in, and there are specialist groups around the world who know how to get best evidence from children and from vulnerable groups. I'll give 3 quick examples of evidence gathering from children. When I was chair of the Bar Human Rights Committee, we had a 10-year project in Nigeria, which was specifically training the lawyers and training the judges on getting best evidence from children in Nigeria, particularly those children who were complainants of sexual offences. Now, one of the difficulties that you encounter is always what space do I have? What structure do I have for the child themselves? And that is where it can be difficult within a conflict zone. If you can have the child in a space where there is no pressure of time, where there is no trauma surrounding that child, then that is a very good starting point. Your general rule is don't try and get evidence if you've no time to collect it in full. A second example was Sri Lanka. Now, this is going back to 2014. There were many complaints of sexual violence. These were the so-called white van kidnappings, where Tamils were bundled into vans and taken to law enforcement centres and tortured through the use of sexual violence and other forms of torture. And they were interviewed, in fact, at their place of seeking asylum. So we had a team of lawyers who interviewed them within the UK. Many have been granted asylum, others were seeking asylum. That was your perfect condition because there was time and there was spaces where they were not going to be re-traumatized or re-traumatized to a significant extent. It could be mitigated. In view of the time I have, I'm going to skip through Colombia very quickly. But it's a very interesting example. Now, this is where reconciliation was really considered alongside prosecutions. And what the president of Colombia did, whilst building up to a peace accord, was he would go to different parts of the country and offer public apologies. And one public apology that I got involved in was mediating between a peace community of cacao farmers and the Colombian state over a massacre in 2005. And he through also the legal process of a court order from the Constitutional Court, he addressed the community in a public apology, where he also rejected stigmatization of that community because they've been stigmatized as terrorists, as FARC, and so on. The HEP, which is the ongoing Jurisdicción Especial para la Paz in Colombia, is worth considering. It has 3 permanent committees which look at territorial and environment sections. It looks at ethnicity and it looks at gender. And it has specific procedures which are focused on those particular areas. I'm going to finish really with an emotion, a sentiment, but also a reconciliation tool whilst looking at conflict resolution, which is forgiveness. And President Santos, as he then was in Colombia in relation to the conflict resolution I worked on, he ended up saying this to the peace community. He said, we do not agree with phrases or attitudes which stigmatize those who strive for peace and reject violence. On the contrary, we consider that every defender of peace and human rights must be praised and protected. For this, we ask for forgiveness. He said, I ask for forgiveness. And I do so with the knowledge that forgiveness is a condition of peace, and that peace is the only guarantor that there will be no more victims. Thank you.
Turner.
Thank you, Dapo. Thank you very much. It's an enormous privilege to be here with you all today, and particularly with many of you who've come from Ukraine. Today's conference, as Dapo said, is specifically on the crime of aggression, but it's important also to reflect on the wider impact of the war and situate the tribunal, the Special Tribunal, within that broader context of accountability. And so I intend to address my brief comments this afternoon to two areas: that wider context of just accountability within which the tribunal must sit and be legitimised, and we've heard quite a lot about legitimacy today, and then also, secondly, a focus on the composition of any future international tribunal, which is also important for the legitimacy aspects that we've been talking about today. Traditionally, international law hasn't recognised individuals as victims of crime of aggression because it's a state-centred approach, it's a top-down approach, it's aiming for the top, it's not an individual-oriented approach. But the reality, as we heard from Svetlana and others today, of course, is that the war is not just playing out for individuals now, but the consequences of that will play out long after the war comes to an end. And what that means in practice is that justice may be delayed or even denied to people on the ground now, living the realities of war. And so it seems to me that the Special Tribunal, to recognise its legitimacy and to argue for its legitimacy, must be settled within a broader context of accountability, accountability that sits also within the broad sphere of international justice, but also domestic systems. International courts, and not least in this example where we're talking about the crime of aggression, may well be viewed as the pinnacle of that justice. But justice and accountability will require a multifaceted approach. The International Tribunal that we've been talking about today is a part of it, but it's not the whole of it. It will require the fostering and advancement of a much deeper cultural, economic, and social sense of legal justice, both within Ukraine and in the wider community. Dapo's already referred to a range of measures in international justice, of course, the ICC prosecutions, and we know that the Office of the Prosecutor is already deep into investigating various war crimes. And separately, I wanted to say that the Office of the Prosecutor of the ICC has also committed to integrating a gender perspective and analysis into all of its work. And that too is important, because the language of accountability has to be diverse and it has to reflect the range of experiences on the ground. There are now very significant and credible accounts of rape and sexual violence being used as a weapon of war. Accounts themselves that have been reported, documented, collated by women, as lawyers, as prosecutors and law enforcement agencies, as civil society, and as refugees and those crossing borders. Those voices all need to form a part of this system of accountability that we're talking about. And for a special tribunal to gain the kind of legitimacy that we've been talking about today, it has to be situated, in my view, in that broader context. The full scale of conflict-related sexual violence is not yet known, and the danger of these so-called hidden crimes is that they too will be cloaked with impunity, and that's why the conversation needs to be wider. The Independent International Commission of Inquiry on Ukraine indicates that sexual violence in this war has been perpetrated on victims from age 4 to over 80. The reality is that most crimes which arise out of this war are bound to be prosecuted in the Ukrainian courts. The Office of the Prosecutor General, and we were very lucky to hear from Andrei just in the panel before, are documenting and investigating tens of thousands of alleged war crimes. And they will continue to need international assistance on many levels, for the documentation itself, for the preservation of evidence, for the sensitive and difficult engagement of survivors and witnesses, many of whom will be suffering severe trauma, and then, of course, to pursue cases within a legal system that is itself dramatically overburdened. There are lessons, too, to be drawn from previous conflicts. Kirsty's mentioned some, but I'm thinking in particular, and we've heard, I think Toby was talking in the session before,
about lessons from the former Yugoslavia. There was very widespread, or perhaps it was Mark, there was very widespread sexual violence in Bosnia-Herzegovina, and survivors are today waiting for justice or have died without justice. I understand that since the establishment of the special tribunals for Yugoslavia and Rwanda in the 1990s, fewer than 100 charges have been brought against perpetrators of conflict-related sexual violence crimes, and less than half of those has ended up with convictions. Those lessons need to be drawn and taken not just for Ukraine's own internal processes, but also for the international community. The tribunal on its own can't provide either justice or peace or security. It needs those range of measures. And some of the things perhaps we might talk about in questions are the kind of ideas that will be necessary, the sort of lessons maybe from from Yugoslavia, from other conflicts, which matter when we talk about these wider issues and what justice looks like to individuals on the ground. Universal jurisdiction is something that Dapo mentioned. And of course, when we think about universal jurisdiction, we need to think not just about the concept of it, but how it applies in our own legal systems. A message for politicians thinking about how atrocity crimes and provision for atrocity crimes can be strengthened in our own legal systems. So too about the International Register of Damages. And we need to think more broadly about psychosocial support, technology support in courts, and how that might work in the Special Tribunal. We also need to think about the importance and role of our own policies and how they affect individuals on the ground. Migration and trafficking policies, for example, bearing in mind the high risk of sexual exploitation for women and children who fled Ukraine. All of that is context in which the Special Tribunal must sit. Very quickly then, I want to just turn to the question of gender parity and international justice. And it is very fitting that this is a panel almost all of women, and the panel before us was in fact all men. The premise is that gender is everywhere and sometimes apparently nowhere. International law is apparently genderless and yet has been dominated by structures and institutions that have historically excluded women from the centre of international law. It doesn't have good form historically when it comes to recognising and relating to the importance and centrality of women's voices. Less heard, still less seen at the top tables of international diplomacy, the Security Council, and public international law itself. That is changing very slowly, but there has been significant underrepresentation of women on international benches. Gender is an important part of our identity which informs our experience, both of which inform our judges. It brings legitimacy to make sure that we have gender parity and context and builds trust between communities and institutions. But it also means that those experiences and identities can have a positive impact on the outcomes. I haven't seen him, but I know that we have Richard Goldstone here today, who I understand has said that without women involved in the early days of the ICTY, there would not have been any indictments for gender-based crimes. Of course, in the context of this special tribunal, we're talking about the crime of aggression. But a gender-balanced, a diverse judiciary may and should positively inform and influence the development of international law in this doctrine. We know we're doing something new. With the development of a new special tribunal should come the possibility and opportunity to adopt an approach to an international law which is inclusive, gender-focused, and transformative. And I started off by saying that traditionally international law has not recognised individuals as victims of the crime of aggression. And maybe we need to think about that in the context of a broader and more inclusive consideration of how this crime can be prosecuted at a special tribunal. So my last words then to the outgoing president of the ICJ, Joan Donoghue. Each time that I gaze out at delegations representing parties, she says, I'm struck that their composition bears too much resemblance to the groups of persons who gathered in 1945 to draft the Charter of the UN and the Statute of the Court. Very few of the Council are from developing countries, and almost all, regardless of nationality, are men. This, she says, is an unsatisfactory situation. I'll leave it there.
Thank you. I was going to say you need no introduction.
No, I do.
Alicia Kearns, MP, who's chair of the Foreign Affairs Committee in the House of Commons.
Perfect. Good afternoon, everyone. I've been asked to comment on the political perspective of why we need a special tribunal from the concept of the impact of the war. We've heard a lot today about the risks of a special tribunal, but as a politician, for me, this is a political imperative. A tribunal is absolutely vital, and there are 4 groups of reasons why. The first is the moral, the second is the geopolitical, the third is the need to uphold the rules-based system, and the final is that truth matters. I'm very fortunate as a British MP that since the start of this, the UK has been clear that this was an act of aggression. But I flinch every time I hear on the media or in conversation or even in Parliament the use of the term Ukraine war. This is not a war. It is an act of an aggression. It is a renewed illegal invasion. And when we call it a war, we change the history, we change the future, and we change the ability of Ukrainians to get justice. When it comes to the moral, we all know that justice and accountability matters to survivors. It matters because they can heal and rebuild. We know that traumatized societies suffer more. We heard that just now when we talked about the Balkans, and I spent a lot of time working with Kosovan and Bosnian women who were raped but were silenced. I remember when I returned from Srebrenica, I went to see the societal group called Remembering Srebrenica, and I said to them, you have been marking this genocide for well over a decade, but you have never had as a theme sexual violence. And they said, well, people don't talk about it. And I said, no, the women don't talk about it because they didn't have the time to heal, the space to heal, because they had to rebuild their society. It is your job to give them a voice and to talk about what happened to them. Secondly, we know that we need to recognize the loss and the pain, and again reiterate that this was not a war. I believe deeply that survivors need a day in court. And when I meet with Yazidi victims of Daesh, it frustrates me that too few of them will get to sit in a court and face down the people who imprisoned and raped and treated them as slaves. Again, we also need to affirm that those Ukrainian refugees who came here for safety, that they too went through torment. I remember the 2 families who came to live with me when they arrived in their cars. Their children had soiled themselves because they'd been too scared to stop until they got to my home. And their car was full of gifts for me and my family, not things for them. We also need to make sure that stories are heard. When I brought 4 female Ukrainian MPs to the UK just 4 weeks after the start of the renewed illegal invasion, they didn't want to talk about sexual violence because they said, well, we've only had 2 or 3 reports. I said, if you've had 2 or 3 people brave enough to come forward, that means we are already in the tens, if not the hundreds. And stories matter because that's how we recognize that men, for example, are victims of sexual violence, that there are all sorts of different atrocities committed and that they were industrialized and that they were instructions that came down. And finally, because truth must be established. When it comes to the geopolitics, and people don't like to hear this, but Putin must lose and Ukraine must win. And we need a legal determination to set that as fact. Secondly, we know we are in an era of deterrence. We have never seen such a dangerous world, whether it be the Middle East, whether it be Taiwan, the Balkans, the Ku Belt, space, the Arctic. Competition is getting hotter and hotter. But worse, we see irredentism on the rise. This was not war. Again, this was aggression. And we need to send a clear message, particularly to those autocrats who gain such political wealth and success from irredentism, that you cannot achieve sovereignty through violence. If we do not send that message now, then when will we? Finally, there is the economic prerogative and the domestic prerogative. We are very lucky in the UK. I've just come back from the Hill 2 weeks ago in the US, where they talk about Ukraine, they talk about an end to the war. In the UK, the public still want to see justice. The public want to see an end on Ukrainian terms. But the economics are substantial. We do need to see justice. We need a solution to this. We need to see a legal determination so that we can have the reparations that are needed, so that we can, and although I will point out we should be able to seize assets without waiting for that, but we also need it because we need to see justice so that other countries recognise they cannot act the same way. The third area is the rules-based system, and we all know this is under attack, or it's trying to be rewritten, which is China's preferred approach. But where are we? We allow the rules-based system to be rewritten and be undermined when we do not take up the fight within it. I am tired of hearing colleagues and media commentators criticise multilaterals when multilaterals are made up of their member states. Before I was a politician, I was asking, where is the Western-backed candidate for the presidency of Interpol? Who were the two candidates in a fundamental role for justice in the world? A Nigerian backed by the Chinese and an Emirati who had tortured British nationals. Who won? The Emirati. Where was the Western-backed candidate? We have one this time, but it should have happened last time as well. And it is also important because there are some who criticise our commitment to Ukraine, and they suggest we haven't done enough to support others. Supporting Ukraine, choosing to support Ukraine is helpful for those who have not had justice. Please make sure we do not allow ourselves to be criticised by those. And we also have to show that even those with the UN Security Council veto can be held to account. The final point is around truth, and we are in an era of hybrid warfare where the weapon and actually what we are fighting over is truth. It is what weighs out, it's what determines whether someone gets on a plane to go and blow themselves up. It is what determines how someone chooses to act in their daily lives, what political parties they support. And the law determines facts. It is absolutely vital. We need to tackle the insidious industrialization of war crime denial that we are seeing, because it is an attack on survivors. In my maiden speech, I said I'd be a voice for those who others seek to silence. Russians are seeking to silence Ukrainians now, and they will continue to do so. Truth is a fundamental for future. It is important to deter, to acknowledge, and to prevent. But denial is a deliberate and calculated attack on survivors. It is a weapon. It is the continuation of violence that began in killing and continues and is re-legitimised through the falsification of history. We saw that in the Balkans. We see it in the Balkans today. We see it in Russia today. We will continue to see it as Russia tries to rewrite history in the future. So it is not just Ukraine that needs and deserves justice. We all need to see justice served. It is a political imperative if we want our children to grow up in a safer world where the rules-based system and international justice mean something. So I hope for Svetlana's future, I hope for my friend Andrei's future, and I hope for all Ukrainians that the G7 will come together, move as one, and bring forward a tribunal, because politicians around the world, and particularly in Europe, we are united that we need one, and we need it now. Slava Ukraini, thank you ever so much.
Just put one question, different questions to each of you before we go on to the Q&A. In this panel, we've been talking about the range of mechanisms that exist for international criminal justice beyond the Special Tribunal for Aggression. And I had a question actually for Shona, first of all. And it's a question that's been posed with regard to the creation of the tribunal, which is, do you see a risk that this discussion we're having today, which we've been having all day today, will somehow overshadow and perhaps even undermine these other mechanisms for establishing accountability, undermine the ICC in some way or the other mechanisms?
Thank you, Dapo. I think there are short answers and long answers to that question. One of the things that we have been thinking about all day is the very substantial number of challenges for the Special Tribunal in all sorts of ways. We talked about the in absentia issues just before this break, and of course we've talked about legitimacy. There are very real questions on legitimacy in terms of gathering political will, and there are real questions on what justice is going to look like. Will we get there? So it's really important, it seems to me, that the Special Tribunal, in order not to be seen to fail, in order not to be seen as a purely Western construct, in order not to be seen as something that will either uphold the rules-based order and uphold international justice or not, has to be situated in this wider context. It seems to me that you can't just talk about the Special Tribunal, and you can't just put money and political will and political impetus into the Special Tribunal it's important. Yes, it is. We know why it is. We've talked about it all day. But we have to also build the frameworks within it's got to sit. We know it might take many years. People don't have many years. We know that from Bosnia. We know that from other conflicts. And we know that Ukraine is going to have to prosecute a lot of crimes, huge numbers of crimes itself. We're going to have to help it. So I think the Special Tribunal is an important part of a much bigger, more layered framework. And I think it's important not to lose sight of that.
Svetlana, let me turn to you. You're from Ukraine. You've been covering the war in Ukraine as a journalist as well. And it's picking up on something that you said, really, and it's about justice. What does justice mean for Ukrainians? So we've spent the day actually talking about international criminal justice. So it's about putting people on trial, creating a tribunal, and having a prosecution. But of course, there is a war going on and people have to lead their daily lives. And so the question that perhaps you could help us with is the question of how people in Ukraine see this question. Is it about wanting peace? Or do they really value this process of seeing a trial, having a tribunal? It's the old age question, peace versus justice, and trying to get a Ukrainian perspective on that question.
Thank you. Of course, Ukrainians are the first people who want peace, but how can we ensure that that peace is going to last? Because we had the case that Russia invaded us in 2014, we had Minsk agreements, and we had so-called ceasefire, and Russia invaded again then. I think the main reason was because the West didn't react at all to the invasion of Crimea and the war in Donbass, and Russian politicians and Russian command, Russian soldiers, they didn't bear any responsibility for that, just some sanctions, and that was the main reason they felt, okay, that if I can invade the country and go unpunished, then I can do that again. So the tribunal is important and prosecution is important to make sure that Russia doesn't invade again, and because even when Putin's power is over, we don't know who is going to come after him and what the appetite of that person will be. So we have to show that every aggression will be punishable. And that's why, of course, Ukrainians support the tribunal and they dream of seeing Putin in the prison. And also, what I forgot to mention is that for Ukrainians, it's important to find a way how we can bring all of our deported children from Russia and also prisoners of war and political prisoners. There were over 20,000 deported children that are right now in Russia. And right now, there is no way, doesn't exist any procedure how to return them unless Russia is willing to do that. So these are all of the questions that are disturbing Ukrainians, of course, and the tribunal is important to find a way to solve those problems.
Okay, I've got my eye on the clock, and I've just realized I was caught out in the first panel. That clock is 10 minutes behind. I think it's 10 minutes behind. So we've only got 15 minutes left. So why don't I open it up, actually, to everyone else for Q&A. I've got a couple of questions I wanted to ask, but let me open it up. So if you'd like to ask a question, please raise your hand, introduce yourself. So we've got two people here. Yeah.
Hello, I'm Frank Hofmeister, European External Action Service. I was on one of the panels in the morning. I wanted to ask the chair of the chamber. UK is always very pragmatic and renowned for action. One of the concrete results we've discussed is the ICPA, the International Center for the Prosecution of Aggression, set up in The Hague. And Mr. Kostin has explained to us how important it is. The United States have decided to cooperate with the ICPA. What is the position of the UK? Are you considering joining or supporting, or this could be a concrete action already today?
Well, as a backbencher, and a humble one at that, I'm actually going to refer your question to the Attorney General, who will be taking the stage in about 15 minutes, only because I don't know. And the joy of being a backbencher is that I don't make policy, but I spend a lot of my time damn well trying to shape it. So I don't know, because I don't believe that decision's been publicly made as yet, but I'm sure she'll be very happy to store that up as a question for her to answer. I apologize, I hate passing questions on, but I genuinely don't know the answer to that one.
Okay, I think Tatiana?
Thank you very much, Tatiana Nesterchuk. My question is rather more practical. I think somebody mentioned that this tribunal is important. And I mean, as a Ukrainian myself, I can only imagine how important it is for the rest of Ukrainians. I mean, we know that Dmitry Medvedev recently said that the existence of Ukraine is dangerous, mortally dangerous to Ukrainians, because apparently Russia will never stop trying to kill Ukrainians who are occupying, according to him, Russian territories. So this tribunal we know is necessary, but what about the practicalities? And the most important question is one of funding, because we know that there are victims of war who need this money now. So where's the funding for the tribunal going to come from? And is there any way of making this sort of, doing this well on a budget?
Okay, I'll put this, maybe to those of you who've been involved in international criminal tribunals, maybe Kirsty, you want to have a go, but also I want to come back to Alicia actually in relation to an aspect of that question, which is, you know, is it worth spending all this money? But we'll hear about how much money first, yeah.
Yeah, I mean, the short answer is you can't do it on a budget. I mean, my experience has been predominantly in Colombia with setting up special jurisdiction, the HEP, and also the struggle in Iran to try and get accountability for the massacre in 1988. And what they do is they will almost have a people's tribunal because they cannot get any infrastructure for any support internationally, including through the UN, to actually set up the tribunal itself. So it's a political point on where the money comes from and how much. And I think, as I said, it's not just the money, it also is the people resources, that you actually have the right people with the particular training to gather the evidence, and the longer that it's left, the more that evidence will disappear. And that's one thing we found to try and get some accountability for in relation to Iran, in that a lot of those mass graves now are concreted over. And also any witnesses at the time, a lot of them have now died of old age. So the time, I mean, there's also, I should say, on another point, just on looking at tribunals across the Caribbean, which are always set up on big corruption cases, they are quite controversial because of the time that they take. And then at the end of it, what actually is the remedy, even on something a little bit more straightforward, looking at you know, a huge fraud. And when you've got something like this, where you've got a crime of aggression, you've got sexual violence, you've got mass displacement, the difficulty with the politics involved is that means it's very important to try and get a neutral space now where you can actually get some remedy. And that remedy also includes money and aid to those people who are suffering, because otherwise they're not going to actually see the outcome of a tribunal. And I think that's something which should be focused on much more. The tribunals are never going to be an absolute holy grail as well. So it needs money, but you also have to have the other mechanisms alongside.
So I would, and this isn't political rhetoric, the cost is higher if we don't act. You know, the reality is we are talking here again about the fundamentals of the rules-based system. You cannot have a rules-based system if there is no remedy, if there is no judicial system to hold people to account. If the UN, if we send a message that UN Security Council veto holders can just do as they like, what does that say to Xi Jinping? What does it say to Alexander Vucic? What does it say to Putin himself? Because why has Lithuania gone to conscription again? Because the Baltic secret services believe that Putin could be in a position within 2 years to invade one of his neighbours again. 2 years. So no, the cost of not acting is much, much higher. Also on the point about evidence collection, this is what is so powerful, is that so much has been done now. We learned this from Syria. We had to go in as the crimes were taking place and make sure we get the evidence. And in terms of who funds it, the G7 need to find it together. They need to come together and they need to announce an announcement that they are going to fund this together. I would love to see something in time for the anniversary of the renewed illegal invasion. That's unlikely, but we have the NATO summit, we have other opportunities. The G7 needs to act now as one.
Any other questions? I certainly have one. Right at the very back. Yes, please. The gentleman at the very back. I can't see who it is. Yeah.
Hi, Jason McHugh. What I wanted to mention was following on from what you were just saying, actually, about alternatives and being overshadowed by the oxygen on this, which is very important, couldn't agree more. There is an alternative. There are alternatives out there which can provide accountability, for instance, domestic courts. Not just universal jurisdiction, there's plenty of other cases that can be contrived, but it can fill some of the accountability gap. And that is on providing compensation, which Ukraine needs, but also on getting those that facilitate this war. And they're very important because they do fall through the cracks of the crime of aggression because of the control issue. But they're necessarily funding it. And what I want to know is on those litigations around the world, which are on behalf of Ukrainians, what is it that the international community can do to support that, which is a cheap method to support?
Anyone want to take that? So I think the question is around litigation in domestic courts, which are aimed at those who are facilitating and possibly getting compensation. What can be done to support that? Yeah.
If I understood the question right, how the West can help with the funding is to give Russian frozen assets to Ukraine, and they can do it as quickly as possible. I mean, it's possible to do it next week. There just to be a political willingness to do that. And in this way, not any of the taxpayers' money will be spent on Ukraine. It will be just from Russian frozen assets. And in this way, Russia will pay for these crimes and Ukraine will receive so much needed assistance.
So I had one question that I wanted to ask Alicia in particular, because she raised this. Of course, we're talking about Ukraine and about justice for Ukraine. But as you go out there and as one talks about this, one of the questions and we talk about building support for justice for Ukraine, one of the questions that one gets in response is, well, why are we doing this for Ukraine? What are we doing for others who, in other situations? That is sometimes the accusation that is leveled. And I really wanted to come back to Alicia to ask, what's the response that one ought to give to that question?
So this may not be the perfect answer, but I tend to speak from my heart rather than fact, which is why I would never have made it as a lawyer. But I think one of the criticisms we often hear of the ICC is that it only indicts African leaders. So surely this should be welcomed that we're trying to pursue justice against somebody who is not an African leader. Secondly, the point I made earlier in my speech about not helping Ukraine doesn't help anyone else. I find it slightly a straw man argument. And the final point I'd make is quite an aggressive one that I've made to quite a few countries. So since the renewed illegal invasion, I have spent so much time having bilaterals with countries like Benin, Ghana, Ivory Coast, countries that perhaps traditionally I'd have spent less time speaking to, trying to get them on board. And they've said to me, Alicia, we are the non-aligned. In South Africa, I had this repeatedly. We are the non-aligned, Alicia. Well, you weren't non-aligned when it came to Israel-Gaza. That's not a judgment on the side they chose. But you cannot say you are non-aligned when it comes to Ukraine and the act of aggression against a sovereign country and then suddenly decide you are when it comes to a different theatre. So I will be unapologetic. I was respectful until that point. I had conversations where the only things they were interested in were grain and children. I was quite happy to try and recruit their support, particularly on children. But I will not allow this double standard that no one else seems willing to call out, that some global south countries still sit silent on Ukraine as women, men and children are raped and massacred because they are fighting for all of our freedoms and against the idea that sovereignty can be achieved through violence, but they're suddenly willing to be spoken out about someone else. Don't call us hypocrites if you choose to be hypocritical and it decides who you want to support and who you don't.
Thank you very much. Well, I think we've come up to 4:30, just about, though I can't tell because that clock is wrong. And we've got one more session to go, but before we go, it just leaves me to thank our panelists. Thank you so much to Kirsty, Alicia, Shona, and Svetlana. Thank you so much.
Thank you to all the panelists, and thank you, Professor Akande, for moderating again. It's really valuable to root the conversation we've been having today in human experience, because it's that human experience that underpins all these erudite legal principles that we've been discussing. So thank you all for that. Thank you. And with that, it's my huge pleasure to invite the Right Honourable Victoria Prentice, KC MP, UK Attorney General, to the stage, and also Director General Andrei Kostin, who's slightly busy back there but will be up on stage in a second as well, for our final session where there will be a conversation.
Hello, everybody. I'm conscious that this is getting to the end of your day, and it's a very warm room. And we thought we'd try and mix it up a bit, because many of you have heard both Andre and me speak many times. So we thought we'd ask each other questions, which we hope will be more interesting. But we're conscious that we're all that's standing between you and the drinks. So, yeah. Andre, how are you? I haven't seen you since lunchtime.
You know, it's always about time.
I know.
In some days, it seems that seeing someone or not seeing someone from lunchtime means like a week passed. Sometimes you think that, look, New Year of 2023 was just a few weeks ago, while we are living now in 2024. So it's very difficult for me to answer such questions, actually, how are you? And if before, usually you are, okay, polite person, you say fine, and you? And now I'm really, I don't know what to answer, because your mind is busy about other things. You can't think about how am I. Very rarely, actually.
He's right. We know each other well enough to get a bit beyond the how are you. And it is true that we can see, and we see each other fairly often, all over the world. But it's true that all our Ukrainian friends, this time that we see you, we are worried increasingly about you, because the toll of war is really wearing, and you're all tired, and you haven't had a break for 2 years. And I wonder if you don't mind, Andre, if you could share with us a little bit about what your life in Kiev is like now at the moment, for your family, for your friends, for the wider group, as well as your colleagues?
I think that we are living the life of every person in Ukraine. Kiev, thanks to air defense system and thanks to our armed forces, is more protected than some other places, especially close to the front line. Though attacks on Kiev
and civilian objects could be every day. And of course, every morning we are happy that our colleagues, our neighbors, our friends are alive. And on the other side, we are, as I mentioned, living regular life because we need to work, we need to do our job. Doesn't matter what's going on. And this is quite a unique situation when you live at war and try to live regular life. Of course, many people are tired. And as a matter of what to do, we started several different, actually, pilot projects of psychological resilience for our prosecutors. So we're now piloting 2 different groups of specialists with help of our, once again, partners and friends, because we cannot finance it by ourselves, and thank you for our partners who finance it. And it's very important because opening one of such events, I told them that we are fighting for our victory to live in peace in our land, peacefully. But we need to be not only alive, but we need to be, to stay normal people, not to pay for this victory by our psychological health, let's say like this. So I want my people to be not only alive but also efficient, and to stay as people who then, when our victory, after our victory, when we will live in peaceful Ukraine, who will then have an ability to feel happiness.
You were talking to me earlier today about the effect on children of the war, and children growing up into adolescence and late adolescence, and how that has affected their committing crimes, for example, which you've noticed in your prosecutorial work. Do you want to tell everybody about that?
This is one of the most difficult issues on which we are working. Just last year, I mean, literally 1 year ago, when we have a coordination meeting of all law enforcement agencies and security sector, and in addition to our current priorities like investigation of prosecution of war crimes, fighting against collaborants, fighting against organized crime, drug production and trafficking, and many other issues which were prioritized after I was appointed in the August of 2022. So we added the issue of protection of our children, not only the case of deportation, of course, and not only war crimes committed against them, but what's going on with them in Ukraine, yes, and even in the other countries, because I asked, do we really know exactly where our children are? How many of them are in Poland, in UK, in Germany, in Portugal? And this was, very difficult question, because exactly to know where our children are, it's very difficult, because even European countries cannot guarantee that children are located in a specific country, but it's not enough to know in which country they are. We also added prevention and fight against domestic violence. For different reasons, I will not use our time, but as a matter of, once again, as a matter of priorities. And if for domestic violence, I think we have positive results. I will mention, we have raise of statistics during 2023. But we think that it is positive because we invested a lot, and if we did nothing
we could have more severe situation. On the other side, this is also an estimation of the NGOs with whom we collaborate. On the other side, because we did a lot with national police, with other governmental institutions, with the civil society organizations, we start to feel that we have more reporting. So raise of statistics is not only about raising of criminality, it's also about more reportings. While for children, I'm now very open with you, the statistic is quite difficult. We have rates of crimes against children, and we have rates of crimes where children are involved as perpetrators. We have rates of cases where children are perpetrators and victims of crimes between children. We have cases where the age of crime has become very low, I would say. The latest cases where children of 11 and 12 years old were involved. It's not unique. I'm talking with my colleagues throughout Europe, and in many countries, they also see the same pattern, which also brings me to a conclusion that this is our joint problem, and we need together invest more in order to protect our children. While when we're talking about situation in Ukraine, I think it's a clear sign that all of our children are traumatized. Even if you can't acknowledge it, when you're interacting with them, they could be, like normal children, but they're traumatized, and they're much more vulnerable than they were before, for reasons which are objective, like families which are separated, or parents or part of their families, members of their families were died or killed. The issue of unemployment, it's natural, yes, part of our economy is destroyed. So a lot of the people who are taking care of children, they are also traumatized. I mean, school teachers, school guardians, social workers, so they are also traumatized. So we are now thinking about the quite comprehensive approach how to protect our children, because we can't afford ourselves to lose our children. We are fighting to return back those who were kidnapped by Russia, but we need to do everything possible to protect Ukrainian children who definitely suffer from this war. We can't do it alone, I mean law enforcement system. I hope that we will get support from all governmental institutions, and I believe from our partners and friends, because I think it's our common obligation. We're fighting in this war not only for existence, but also for the future, and children are our common future.
Yeah, it's difficult to talk about, but I think because there are a lot of your ambassadors in this country, you have a whole army of women and girls who live with us. I live with some of the people in this room.
This was actually my question to you.
Okay.
You were the first member of the parliament.
I think I was the first altogether because I've got sharp elbows. So we got through the visa system and we got a lovely girl called Vika to live with us.
Yes, could you tell? How it changed your approach to Ukraine, and you are one of the most active supporters, and not only by words, which is important for politicians, but by real actions. And I know how deep are you inside many of our problems, and you really take part of your heart. Yes, your heart is with us.
Yeah.
Does it really? I mean, Vika.
Yeah, Vika.
What did she change in your life?
She's changed everything. So she's 26. She's very beautiful. She's very clever. She speaks lots of languages, and she has become part of our family, and we love her very much. She has her own family, many of whom have come to live in our village. And my daughter lived in Ukraine before the war, and I came to visit her, and I fell in love with Ukraine at the same time that my daughter fell in love with Ukraine. So we are fervent Ukrainian supporters. I had a real difficulty at the beginning of the war stopping my daughter joining your army. I'm sorry I stopped her, but I think many mothers would stop their 21-year-old daughters joining an army when really she's more interested in what she looks like and how long her nails are than how to fight. She wouldn't have been a lot of use. Anyway, she has been a lot of use, my daughter, here to Ukraine, because she and Vika have brought over 150 of Vika's friends, colleagues, relations, friends of friends. And what you were saying about the trauma and the children is something that is literally playing out in our houses. So these are people who left Ukraine, but they are separated from their families. They might have seen, well, almost all of them saw something very bad at the beginning. And they almost all, particularly the ones that came early, had a very difficult journey to get here. And quite a slow visa process until we got it sorted, which we did, to get settled here. And I think the guilt that they feel from not being at home is enormous. And I think it's really a hard thing for them to manage. But from our point of view, from a British point of view, they are brilliant ambassadors. They remind us all of what is going on in Ukraine every day. We love them. They've got jobs. They've integrated. They are clearly traumatized and unhappy, but they are also great people who are getting on with life, and we have come to love them. And that is a really strong thing.
You know,
I'm going to sit here crying now.
No, it's because we are human beings.
Even though we're lawyers, Andre.
Yes. I think we are human beings with all the features. And I know that, I believe that Vika and the others, maybe her friends whom you know now or her relatives, they are really, as you mentioned, ambassadors of Ukraine, and I hope that promoting them to speak to politicians here, to speak to media, I think could help a lot. While, of course, visiting Ukraine is extremely important from my point of view. You know, I heard it a lot from people who are our friends and whom you know, many of them, and they told after first visit that even looking at videos, photos, interviews, meeting with people like Vika, yes, our Ukrainian who are here, they knew a lot. Speaking with people like me, for instance, they knew a lot. But visiting and Ukraine and meeting people in Ukraine, meeting victims and survivors, meeting our heroes in hospitals, meeting NGOs who help our people in different dimensions, really change a lot. How did you change after visiting Ukraine? You were in Bucha, you were in other places.
Do you know, it was incredibly impressive. So I came, it must have been a year ago, because it was, no, it was less than that, because it was the anniversary of when we discovered Bucha. You were there. It was, so Bucha, we all know what happened. It was horrific, clearly. But Bucha now is incredible. It's, this is last year. It was clean. It was well-organized memorial. We laid a wreath, do you remember? The beautiful church has been repainted. There was a beautiful exhibition of horrible photographs of the atrocities that took place in Bucha. And the thing that impressed my legal heart the most was the work that you had already done to bring the perpetrators of that violence to justice. So yes, of course, we feel these things as parents and as lovers of Ukraine and as lovers of the rule of law. Of course we do. But I think as lawyers, we are very happy when the rule of law works and prosecutions happen and we see bad people having consequences and going to prison. And I cannot tell you how happy that makes us as lawyers. I think you get this too, very strongly. So it would be good if you could talk a little bit about the work that you've already done with prosecutions for war crimes, maybe a bit about the sexual violence crimes, so that's very horrible to talk about too, and why it really matters that we're doing the practical, day-to-day, normal evidence gathering and prosecuting right now.
It's very difficult to answer your question in like 2, 3, 5 minutes, because I will give an example. 1.5 years ago, when I've been asked a question of like this, first of all, I remember everything, yeah. And it took me like from 7 to 10 minutes to explain everything. Now it will be about 45 minutes at least, okay. And I need my papers because in order not to forget. It's not about myself actually, because when I forget some piece of work done, it's about my people, because they understand, okay, you mentioned this, but you forget about that, and this is not fair. But I will try to be short. I think that first was about prioritization and formalization of prioritization. So it's about strategies. Maybe you think it's about bureaucracy. No, it's about strategies. And we implemented strategy of investigation and prosecution of international crimes. It took 1 year. It's not a very big document, but it took us 1 year. But this document is created with the help of all of our partners who help us in our accountability endeavors. It is discussed with civil society. It is discussed with professional lawyers. So this is the document which is based on previous experience, but something which didn't exist before. And it gives us an opportunity, not because before I answered how you prioritize these hundreds of cases. Of course I said, look, yes, when we have case when civilians are killed, when civilians are wounded, when they are raped, this is understandable. But we have so different cases, and to prioritize them not by hand, we need specific document. We created a lot of methodological documents, because we don't only created regional units which prosecute war crimes in 9 regions, but we need to train people. We need to establish unified practice, because thousands of cases which are investigated simultaneously, and also by different law enforcement authorities, because literally or by law it should be investigated by state security service, but they have no enough capacity. So that's why national police is investigating a lot of these cases, and you need to formalize it in a procedural way. So first of all, it's about strategic documents, and we have also created strategy for investigation and prosecution of conflict-related sexual violence. This was one of the first. Some others are on the way, of specific types of war crimes which we are investigating. And the other is, of course, creating partnerships. Creating partnerships with different organizations which help us. First of all, of course, is ACA, Atrocity Crimes Advisory Group, and brilliant people who work there, not only in Kiev, but outside. Some of them are now my friends. And of course, I know that how difficult it is also to engage organization which is founded by European Union, United Kingdom, and United States. It took them, please don't quote me, it took them about 1 year to decide between themselves how this organization will work. Yes, I was very pushy, because when I understand, I said, look, I can speak with anyone. Please just tell me whom to speak to expedite this process. At the end of the day, everything is in place. We need to go ahead and etc. The ICC. I think this is historic, and our partnership with Karim also named it partnership, with full respect to their independence of their investigation. But this is because our partnership, because, as I mentioned today, 5 months of intensive work of our prosecutors, our agencies, and the team of Prosecutor Khan, and first arrest warrant were issued. And I mentioned this several times. You know, ICC is a complementary authority. ICC intervenes when national authorities are unwilling or unable. We are willing and we are able, unless we have legal limitations. And of course, Putin, unfortunately, is not our client, because we have no jurisdiction. And I always publicly mention that I'm grateful for the team of Karim, that the first case is fully complementary in nature. And on my side, I publicly promised that I will take responsibility to transfer cases to the ICC if they will be ready to accept, even those which we can prosecute by ourselves. But if it will be for the sake of justice at large, I will do it. Even being criticized that why you transfer case which you can prosecute by yourself, I have arguments. So second is creating partnerships. I could miss many others who help us because we have no time. And third, as I mentioned, is specialization. And I will not mention all of the issues of specialization, but I will, yes, CRSV was the first where we established a specialized unit. It was September 2022. And what we did, we practically used soft law of United Nations, Murad Code. We used it, included it in our official documents as a matter of principles how such cases should be investigated and prosecuted. And this opened the avenue for the next stage, because Murad Code is fully victim-centered, you know, principles of Murad Code. This gives us more reporting, more cases. This brings us such results as we publicly saw in Davos at the Peace Formula meeting of where 80 countries and international organizations met in this January. We pre-recorded video of 2 survivors. And one of these survivors who told her story was a young woman. She was raped in Bucha region in front of her husband by Russian soldiers. And what is important, she not only started to tell her story publicly, which you know how important, it's about courage, and it's about understanding her responsibility, because she did it not because we asked her to do it. She understood that I need to do it, I can do it, I have courage to do it for other victims and survivors of this, one of the most silent crimes. And moreover, she not only started to tell her story publicly, she is now working for one of the NGOs who help other survivors of CRSV. And this is, for me, one of the most visible results of our new approaches, how we work with the survivors of conflict-related sexual violence. Because beginning of this is building trust with them. If they trust us, they then can go public because they feel more, it's possible for them to do it. And when they start to help other survivors, I think it's even more important, because at the end of the day, survivors will better trust the other survivor, who only understand what happened with
the other.
I think some of the survivor films that you've got are quite extraordinary, particularly the young men who've been raped, who speak very bravely about what happened to them. It's been very noticeable here as well that some of the people who've come to live with us temporarily, we hope, have also been able to tell their stories to the police in this country, and we've been able to record their evidence properly in a way that we hope will be useful in your prosecutions or international prosecutions one day. Do you think we've done enough collaboratively around the world to make sure that the evidence is being captured properly and stored in the right places?
This is one of the most difficult questions.
I know, I'm sorry.
Because I really, with all of my heart, share and value all assistance we received and we receive and we will be granted by you collectively. While I can't tell that we receive enough, because we have, some of our counterparties with whom I meet from time to time, and they know that every time I will come with some new idea.
We want a list, Andre. That's fine. You just give us a list.
Yes. This is. I heard it one time when Prime Minister of Denmark told this to my president. So you always have an idea and a list. Yes. So this is. I think this is how we survived the first months of the war, of full-scale invasion, and how we turned some of our friends who resisted a little bit, we turned them into our true friends. And we need to remember all these stories. Because at the beginning, at the first days of war, when many countries thought that we will not survive, our president and Ukrainian people and Ukrainian army showed that it is possible. And a lot of things changed after it. And I said some months after that from 24th of February 2022, Ukrainians believe in unbelievable. So there are no such tasks which we cannot, or such goals which we cannot reach. We just need more support, any type of support. We need to receive ammunition, we need to receive humanitarian support, be it direct budget support, and it's not for us, it's for victims and survivors of this war who without this support, they will not survive because they have no job, or we have no money to pay them social payments. It's the same type of support you pay to Ukrainian refugees who stay here. And we need, of course, political support. And we need everything to receive in time. Time is, we can't let time to be used by our enemy. We need to use time in our favor. And the speed of life in Ukraine is much higher than here. That's why we are so pushy, for you to take decisions in line with speed of life in Ukraine, because some decisions which are positive, but they have been made too late, and it cost lives of people. Very small, very short. We received, during this 1.5 years, practically every type of ammunition which we requested. But we spent months and months and months. At the end of the day, after months of refusals, we receive this ammunition. If we received all of them before, thousands of lives
would be saved. So please, this is what I wanted to tell as a last word. Take decisions in line with speed of life in Ukraine, and you will save lives of Ukrainians. Thank you.
With huge thanks to both of you. That clock's a bit misleading, speaking of time. It's actually 5 o'clock, and I know there are some journalists who are waiting to talk to both of you. Yes, okay. Fantastic. So thank you both very, very much. Before everyone files out, just a final thank you to everyone for coming here today. We hope that you found it a valuable and interesting conference. A few key themes have arisen out of the 4 panels that we've had. The first is the importance of galvanizing political support internationally, including from outside Europe. Second, that there will be no perfect model for the Special Tribunal, but we must act now to deliver justice. And finally, that the crime of aggression is the ultimate crime. It's the mother crime. And justice for Ukraine protects all freedoms and hopefully will prevent similar aggression elsewhere. So if we do not find a means of prosecuting Russia for the crime of aggression, we will undermine our rules-based system. Please, all of you, follow Justice and Accountability for Ukraine. There is a website. If you look at your QR code, there's information there. There's plenty more work for all of us to do. This is not over until there's a special international tribunal for Ukraine. So please do continue to follow the work, the important work that Jaffa is doing, and thank you once again for your support today.